Hello and welcome to the rest of day 40. Happy Thursday, folks. Happy Thursday. Oh. Ugh. Yeah. Okay. There was a bit. I see it's on the thumbnail. It says day 45 part 2. It's not. It's day 46 part 2. I try to do it from work, and I'm having difficulties finding where we left off yesterday. But you all know the rest of the day got interesting. Oh, maybe some of you know. Becca Lynn knows. I saw that in the chat. So today things will get you furious. Okay? Welcome to the show. All right. I will simply go after the morning break. And I wanted to show you this because Law and C-Word changed the name of their stream from Young Thug RICO Trial Day 46 to Young Thug's attorney throws tantrum after judge says he's unprepared. What an absolute disgrace from Law and C-Word. Absolutely disgraceful. So, probably know exactly what I am about to say about that. But let's just get on with it.
Thank you, Your Honor. Detective Quinn, when we left off, we were getting ready to speak about Detective Booker Higgins, but before I do that, I'm going to show you what's already been admitted as State's Exhibit 108C. When we reference Derek Dodson, that's the individual that you met with at the homicide unit.
Yes.
Well, minus the black spring across his face.
Let me know if sound is okay, folks. Okay.
Okay. Now, going back to Detective Booker Higgins, what was your understanding of her involvement in this case?
She was on scene at the time when Detective Robinson discharged his firearm.
Right. And when you had Detective Velasquez speak with Booker Higgins, did she provide a description of a driver of the vehicle that was involved in this incident?
She did, yes.
Okay. And what was the description that was given?
She gave a description.
Yep. Your Honor, Detective Booker Higgins has already testified, so it's not here.
Said it was
I overruled the objection, sir. I overruled the objection.
Thank you, Your Honor.
But what was the?
Said it was a female driver.
Okay. And did that female driver have any particular hair color?
I think she said pink. I'm not really sure. I can't remember exactly. But
All of a sudden, Mr. Queen has a memory loss. Remember, he has prepared for his testimony vigorously, checked everything, and here he claims, oh, they might have said pink or something. Detective Quinn, you were a bad cop. Oh, hello. Thank you. Thank you, Megan. Fox Den raid incoming. Yay! Patty B asks, why does this guy talk like he is so cool? Because he have had a TV show with his best friend Detective Velasquez, also retired. But Detective Velasquez, in his testimony, admitted that as a standard, he erased statements he didn't like and only saved the recordings of the statements that he thought was truthful. Also known as destroying evidence. And this Detective Quinn is Detective Velasquez's best friend. So yeah, it's infuriating. There's a saying in Germany that if you see a follower of Austrian painter at a table and 11 people eating with, dining with, laughing with, friends with, you have 12 Austrian painter followers. As in, if you have a really bad dude as Detective Velasquez who destroys evidence and you keep hanging around with him, you're kind of a bad dude too, in my opinion.
Now, at this point in your investigation, were you now looking for a woman as a part of this underlying assault that you were investigating?
Absolutely.
Now, during the course of your investigation, did you also have the occasion to interview a Leonard Pass?
I did.
And was
Hello,
he able to give you
Megs.
information that assisted with your
Thank you,
investigation?
Megan.
He did.
For you newcomer,
Now,
this guy is a
permission to
liar,
approach?
in my opinion.
Yes, they should have seen these already in Discovery. And I believe I sent them to them previously on.
And don't never take the prosecution's word for sending over Discovery, because several times during this trial they have made their claim, and it's, as it turns out, they haven't turned over Discovery. Hey, hello, Flux, Jeff. Jeff, Flux, yeah, good to have you here. Good to have you here. Let's continue. Ugh. Hey, Angelo.
These are definitely on Discovery.
Broken Baker. Damn, that's a lot of you.
Yes.
Oh, by the way, for you newcomers, this will, Day 46 Part 2 will make you furious.
I'm going to show you.
Because the judge will make a claim about the defense that we all know is completely false. But that is later on. Now we have to endure Detective Quinn, the lead detective in the underlying act that was an armed robbery, where the detectives tried to place Mr. Williams in the car that smashed into a laundromat. Problem is, there's no evidence of it, and the only person who made the claim, in my opinion, was coerced into saying that by
112C.
Detective Quinn.
Do you recognize Exhibit 111 and 112C?
I do.
And how do you recognize Exhibit 111 and 112C?
That's the area that I had a photograph. I had a crime scene tech come out and take pictures. That's my left hand. pointing to a little dot on the ground there.
And is that a fair accurate depiction of the image or the area that you had a crime scene take a picture of back in September 2013?
Yes, ma'am.
Your Honor, this time say like 26, 110 and 111 is happening. I mean, and 112, I'm sorry. Excuse me, 111 and 112.
Thank you, Teddy. Yeah,
No,
it seems to
it's
work.
111 and 112, Your Honor, my apologies.
The bonnet.
Yes.
But I can't have the bonnet on all the time.
Thank you, Your Honor. I'm going to actually first start with what has already been admitted, Exhibit 110C. Looking at Exhibit 110C, do you recognize what's in Exhibit 110C?
Yeah, that's Somerville County.
Okay. And now looking at Exhibit 111C.
For everybody interested, all of these
And looking at
have
112.
already been shown to the jury
Is that
several
your hand
times.
that you were just referencing that's pointing at something in the ground?
That's me. Yeah.
What exactly were you pointing at the
That
ground?
was what was believed to be impact from a projectile from a gun, a bullet.
Show of hands. How many here believes that this is how you show evidence collection and stuff like that? By pointing at something with your finger and taking a picture of your finger pointing at something. With the claim, oh, we thought this was something that a bullet might have struck the ground in the projects in Atlanta. Even if it is, there's no way in freaking hell anybody can testify that came from a discharged gun from that particular robbery. In my opinion. Yes, dear Robertson, marker and number, please. This, and I'm not even surprised because the prosecution's case, this is the level of evidence they are showing. Oh, look at that. Doctor, my leg hurts when I point at it. Doctor, my shoulder hurts when I point at it. Doctor, my nose hurts when I point at it. What's wrong? Well, said the doctor, your finger is broken.
Pointing at the
That
ground.
was what was believed to be impact from a projectile from a gun, a bullet.
Now, during the course of your investigation, did you ever attempt to speak with yourself, either Frederick Prothero and Walter Murphy?
Yes.
And were you able to speak with them?
No.
During the course of your investigation, did you ever meet with the owner of the red car that was used in the armed robbery?
Yes.
And if you can recall about when in your investigation did you meet with her?
I know it was a couple of weeks after, I'm going to say the latter part of September 24th.
So they claim, so witnesses at the time said the driver was a woman. The owner of the car was a woman. I wonder, no, let's take a few weeks finding her. Yeah, let's do that. Yeah. Do you, when you try to clap yourself on the shoulder, do you sometimes miss, detective, and slap yourself in the face?
25th, maybe.
Okay. And I said her, do you recall what her name was?
Maricela Cisneros.
Did she
And
had
tell you, information about her
a
vehicle? Was she able to
huge
give you information about her vehicle,
personalities?
specifically who she had let borrow her car?
She was.
Now, during the course of your investigation, I think you talked about earlier going to do the rodding of the vehicle.
Yes, ma'am.
Did you ever actually do that with the car?
I did.
And when did you do that? Do you recall?
I don't remember the date. I know it was within the week. I had the car sent to what's called the homicide cage, a protected area we put vehicles in for further processing. My goal was to understand that hole in that passenger side front seat headrest.
Did you, when you processed the vehicle, did you, or did the rotting in the vehicle, did you find any shell casings within that vehicle?
I did not.
Mr. Steele?
There were claims at the time that the people in the car fired from inside the car. Here is Mr. Quinn. I assume he really can't lie about it, but he didn't find any shell casings in the car. How about that? So the only people firing guns at the time was the police. Ta fucking da.
And understanding what you knew at the time that you processed your vehicle, was that a surprise for you that you did not find any shell casings inside?
I mean, it wasn't a surprise. I mean, shell casings are fickle. You don't know where they're going to go.
Holy crap. So the claim from this prosecution is that, it's not surprising we didn't find any shell casings inside the car, which we claimed they fired weapons from, because they can get anywhere. Yeah, but they are inside a car. They are inside a damn car. You would assume if you fire a bunch of shots inside a car, you would at least find one shell casing. One. No, they're going to blame the bullet holes inside the car on the people in the car, not the trigger-happy cops surrounding the car.
You don't always find them.
In a moment, I'll be showing some pictures that I've already shown the defense counsel, but I'm re-showing to them again. I want you to take a moment and look through 161 through 174C. 4C, do you recognize those pictures?
Yeah, that's that burgundy Nissan Altima that was in the homicide cage that I wanted to get those rides through.
Okay. And are those pictures of the vehicle at the homicide cage?
Yes, ma'am.
And do those pictures appear to be a fair and accurate depiction of the car at the homicide cage when you went to process or do the ride out of that vehicle?
Yes.
You're right. This time to say like the Senator Exhibit 161C through 174C into evidence.
I'm playing this in 1.25 speed, by the way.
Thank you, Your Honor.
Oh, sorry. Dun, dun, dun. There. A banner.
Looking at State Exhibit 161C, if you just orient the jury as to what we're looking at in State Exhibit 160.
That's the cage. That looks like well, it has some barbed wire. This seems to be a garage of sorts with fences around, but it seems to be. I have no idea. I expected I expected something else. Just to say that I expected something else when they said it was a cage we keep the cars in that was doing processing. Yeah. why isn't there something in between all of these cars? Because if this is just fenced in and stuff, I mean, contamination, cars close by, detective going to check on something, puts his hand on one car, puts his hand on another, and all of a sudden you have contamination.
B1C.
Okay, Patty B says that this is normal. Okay.
Of the car that made impact with 126 Cleveland at the coin laundry.
And let me ask you this, how does the car get from the coin laundry to the homicide cage?
A record, a city contracted record service.
And is that the record that you were referencing or talking about when we listened to the Nava Flores interview when you mentioned that the red car on the record right there?
Yes, ma'am, it was.
All right. Now, going to 162C.
Yes, Ken's counseling coach. Not all cars are domesticated, Nick. Some are feral and need to be caged and aren't safe for untrained humans to interact with. Yeah, it seems like card held for evidence are not wrapped in Georgia. It doesn't look like that. And this is an armed robbery case. Yeah, I expected something to be in between the cars at least.
Is that appear just to be another angle of the vehicle inside the home? What's in State Exhibit 162C?
It's just a front end view of where that vehicle made impact with the laundromat.
All right. 163?
That's the rear trunk compartment of the same vehicle and a rear view.
All right. And looking at 163C, is the top
At the scene, that blue thing there that you see was outside of the car. And they just threw it in the trunk without wrapping in it or anything. They just, the thing outside the car, they just threw in the trunk. That's not preservation of evidence. I have no idea what's in that blue thingy there. Seriously? Seriously? I will try to find those pictures from the crime scene so you will know what I mean.
of the trunk on the car? The actual roof of the trunk?
I don't see where it is. I'm not saying it.
Okay.
Looks like it's just off.
Looking at State Exhibit 164C? What are the jurors looking at 164C?
This is that area of concern for me. Again, I'm investigating the actions of a police officer using deadly force. That's what my mind is. That vent window, the rear passenger view is what I'm concerned with and how it may correspond with that headrest of that front seat. I got a man shot in the back. I got to explain that.
Okay. And looking at State Exhibit 165C?
That's a closer view of that same rear passenger vent window. You can also see the airbag deployed from the driver's side.
166C?
That's another view. We're getting closer. You can see that defect to the right side of that headrest. That's my area of concern. That's a through and through hole. And that was of paramount concern to me at the time.
Now looking at 167C?
That's going to be the rear passenger compartment of that burgundy Nissan owned by Mrs. N.Starow. You can see blood transfer. There's some items on the floor.
Now, at the time, did you request for any testing or anything to be done with the blood that was in the backseat of that vehicle?
Not the blood, no.
Why not?
I didn't think it was. I mean, I knew I had a shot person in the backseat, so I wasn't going to send off to the GBI and make sure that was blood. I mean, they don't. Yeah.
All right. 168C? What are we looking at 168C?
Well, this is a very rudimentary, not very scientific. It's just a brother taking the stick. That's all I did. And running it through that hole, because I'm trying to tell this story. I'm working this deadly force case. And I want to make sure that that was going to be a path of a possible bullet fired by the Atlanta police.
And at the time when you're doing this, did you have information of the officer shooting into or in the direction of the vehicle?
Based off his statement, the way he broke it down, I had pretty good idea exactly what happened.
Looking at Exhibit 169C. What are we looking at Exhibit 169C?
This is going to be an interior view of the same information. Those rods, I've actually got them now going through, showing the trajectory, which corresponds with the wound that the 6'8" Mr. Frederick Prothro had to his back. Thank God the brother was 6'8", or it would have been in his head.
And outside of that bullet hole in the vehicle, did you notice any other bullet holes within the vehicle?
I did not.
Okay. Looking at Stacey Exhibit 170C.
It's another closer view showing the trajectory. That hole where it originates at the rear of that headdress, it's actually coming through. And I believe that is the wound that Mr. Frederick Prothro received from the Atlanta police.
Looking at Stacey Exhibit 171C, is that just another close-up?
That's just another of the same.
Okay. 172.
It's a closer view of the rod actually coming through the headdress.
And 173. And again, 174.
173 is also the very same thing. 74 is just, that's me actually holding it, very unscientific, but just trying to tell a story.
Now, you talked about not finding any shell casings. I want to go back to Stacey Exhibit 167 for a moment. Now, when you were at the homicide cage, were you able to observe this vehicle in this condition as it is in this picture?
Yes.
Okay. How tall are you?
6'1".
Looking at that photo and your personal observation of looking at that vehicle, are you able to fit in the backseat of that car?
Yeah, it'll be crunched, but I'll be back there.
All right.
So he's 6'1". And yeah, he could fit in the backseat of that car with a crunch. Yeah, but if you had a 6'8" person in front of you, I mean, this is a bad claim because, first of all, Mr. Williams is about 3 inches taller. Because if Mr. Quinn says he's 6'1", he's probably 5'11". So yeah, not very scientific at all. So I don't buy this claim at all. Oh, and by the way, I found see this blue thing outside. They just threw it, and this was more or less still nothing was poking through it. Let's see if I can just temporarily, let's see, where are we? 220 something. But here you see the same blue package of, oh, sorry. Here you see the same blue package in the impound with things sticking out of it. And hold on. But here, it's sealed. That, yeah. That's not how you handle evidence. Just saying, that's not how you handle evidence.
Looking at that photo and your personal observation of looking at that vehicle cage, was this the condition that you found that vehicle?
Yes, ma'am.
Okay. Do you know, or to your knowledge, were there items in the car prior to you seeing it at the homicide cage?
Yeah, good question. Where is all the stuff supposedly in the back seat? right around here on the back seat was a toolbox. Beside it was, I mean, sure, they could have taken all the evidence out and stuff out of it. But where are those pictures when they collected the evidence? Who's to say things weren't moved? This is so bad. This is not how you process Jesus Christ.
That's another view. We're getting closer. You can see that defect to the right side of
Now, when you got to the homicide cage, was this the condition that you found that vehicle?
yes, ma'am.
Okay. Was there, do you know, or to your knowledge, were there items in the car prior to you seeing it at the homicide cage?
On the 126 Cleveland Avenue address, there were 3 firearms that were of particular concern to me, which I had collected by the officer I delegated, or the detective, Somerville, to collect.
Do you recall?
Oh. It was nothing. The trunk lid popped off the car when they drove out. See if I can find those pictures. Hold on. Let's see here. Here is another. Here is the trunk that was almost popped off completely. Where did that go? Yeah. The way that is, but here's the good thing. He will be cross-examined at one point, and I assume it will be fire.
158, 59, 160, I believe it's gonna be through 169. Sure.
Ooh,
And
I have to
actually-
show you something else. Hold on. This is from the crime scene. This thing, well, here's the back fender, bumper, whatever's. That's the spare tire. That's the cloth thingy or whatever's that holds the tire down. Oh, yeah. Let's see if I can. No. Is it there? But all of these things were left in a trunk. How did those, the spare tire, pop out and these things stay in? And this blue thingy with the whatever is what it was in it was outside as well. Where are these things from in that picture we just saw? I mean, something really sketchy is going on. J-Shield SD. So how does this make a RICO case? Well, the Georgia RICO Act is so broad and so vague that the criminal enterprise and that the prosecution alleges that YSL was, it's enough to have a spoken and sometimes unspoken agreement in furtherance of the criminal gang. And what one person does that is associated with or in the gang other people under the Georgia RICO Act can be guilty of it, even though charges was never filed against them. That's the Georgia RICO Act.
Need the J. Looking at 67150 September 11. Do you recall seeing those items while you were
Oh,
looking
yeah.
at the Ron scene, like on September?
This is where the prosecution claims the backseat. This was where 4 people were. Oh, well, driver, passenger, and 2 people in the backseat. They assume that somebody sat on either the toolbox or had a screwdriver up their ass. Seriously?
September 11.
I don't remember seeing him. I mean, and I wasn't looking for him. Honestly, I mean, I delegated.
You were there, you took... Detective Quinn doesn't recollect these things being in the backseat. Really? Well, they could have been processed and everything taken out of the car, as it should have been. And we don't know what happened between then and when Detective Quinn went there, seeing no shell casings. What we do know is that in evidence, there are 0 shell casings from that car. 0.
That out. I had a lot going on. Those guns were important to me at the time.
And this is
Who is all the guns? Okay,
Yeah, I
so
mean, you
where
can't do
were
it all.
these
You gotta
things?
depend on the people you work with to actually, execute what you needed to do. I'm in the fog of investigation. I need help, like everybody does.
So I want to look at 157. Looking at Stacey on 157, can you describe to the jury how that toolbox is positioned? Is it laying flat on the seat or is it kind of raised up a little?
It looks like the front end of it is on the seat and then it's propped up against the back of the back seat. It's like the driver's side back seat.
And is the blood underneath the toolbox?
Yeah, I see some transfer of what appears to be blood, yeah.
And to your knowledge, do you have any idea how the items got on the seat or those items?
Objection, this witness is not a blood spatter expert.
Or actually in the toolbox prior to this picture being taken?
I don't know anything about that.
All right. That's it. Thank you so much. Items such as that, would you have had those processed or taken to the GBI crime lab to be processed?
I wouldn't.
Why not?
I didn't feel they had anything to do with the case I was investigating. It was paramount concern is the officer used of deadly force. I had a good idea of what happened in that scene. We don't just send arbitrary items to the GBI for testing. That's a call I made. They can blame me, but I didn't think they were relevant.
Now, before we move on to the next scene, what you've testified so far is a couple things that.
Testimony. I want to
When did this incident occur?
9/11/2013.
During the course of your investigation, did you get jail calls in this case?
I did.
Okay. Tell us a little bit about what are jail calls.
Jail calls are information stored on some server at the jail for anyone incarcerated that makes phone calls.
And how does the individual who's incarcerated make those jail calls? Do they have a PIN number? What's the process?
I don't know how they make the call, but I know how we can listen to them as law enforcement.
Okay. How do you all listen to them as law enforcement?
So there's an app that they gave us access to. When I say they, I'm talking about the police department, the Atlanta police. At that time, you could actually punch in and listen to people in real time almost with your cell phone. It was that far advanced. You could listen to specific conversations based off the name of the inmate.
And when you listen to those calls, do you know if they are in an area called booking or if they're in general population? Are you able to determine that from the call?
I can't determine from where I sit, as I recall 10 years ago. I just know that usually when people are talking, you can.
Your Honor, cause of speculation. One second. That's right.
Have you had the occasion to have or listen to calls the individuals make when they first get into the jail?
Yes.
Okay. And then listening to more calls once they've been in jail and
If I'm the way, I mean, he started sitting right around there, looking at the prosecutor, answering. Now he is staring at the jury. Seriously, Detective Quinn? Now, for expert witnesses, it is quite common to sit a bit in between, listening, because they are explaining things to the jury. But to sit, listen with one ear, staring the jury down, that's a bit excessive.
maybe have one in the general population.
Yes.
Now, in this case, when did you pull jail calls in this case? For what date?
I wanted 9/11. If that, that's the first significant data that sticks out, but I wanted to see if there were any calls.
At the time of 9/11, how many people out of the 3 that you said were detained were actually taken to the Fulton County Jail?
Just one,
Who was that?
Adrian Bean.
And did you pull the jail calls for Mr. Adrian B?
I did.
When did you actually start listening to the jail calls?
It was several days. I think around the 16th, if I'm not mistaken.
Would you have put that date in your police report?
Yes.
We're looking at a copy of your police report, help refresh your memory as to when you started listening.
Okay.
Okay.
Can we check the metadata from that police record to make sure it hasn't been altered with during the years?
I'm going to show you what's been marked as Exhibit 178C. Just look at that, tell me if you recognize Exhibit 178C.
Yeah, I recognize this as my supplementals.
And is that a fair and accurate depiction of your supplementals regarding this case, the officer involved shooting?
Yes, ma'am.
And again, we're looking at a copy that help refresh your memory as to the date in which you started listening to jail calls.
Okay.
And I'll specifically direct your attention to page 30 of 47. At the top and at the bottom, you might say 42.
Said 47.
30 of 47.
30
Yeah.
or 47.
Please hit that thumbs up. Really helps the channel. And subscribe if you haven't done that yet.
And I
You know
apologize,
all the
it might be 32
YouTube
of
things.
47.
This one, for whatever reason, is out of order. Went back to 20. Okay, hold on. It might be me. Hold on. User error. I'm sorry. Hold on. Here we go. Yeah, 9/16/13.
There are 300 watching and 100 likes at the moment.
And when
We
you
should
start-
be at
When you start listening to jail calls,
we should be at least at 50% of you pressing the thumbs up. So I need 50 more of you. It honestly, it really helps against the algorithm. And to, it just helps. Oh, Nana Misty, thank you so much. Gifted 5 memberships. That's so sweet of you. It went to Ayana Davis, AJ Tyler, Lolita Smiles, Susan Stevenson, and Rod Squiles Betsy. Yay! Everybody thank Nana Misty for gifting memberships. And now you guys have access to all my members-only content. It's at least 50 hours of members-only content on my channel. So you have, and it's about my farm, bit of work, stuff. And for you who don't know, hi, I do labor law. I have an actual law degree. I'm a junior rep, and on my spare time, I make commentary, snark, and shouting about American trials. Yay!
on 9/16/13, did you get calls that were in between these dates?
I don't remember. I don't remember that.
Would it be safe to say that any calls you would have heard would have had to happen before you listened to
Oh,
them?
yeah, absolutely.
So roughly between 9/11. In preparation for this case today, have you had an opportunity to listen to some of those jail calls that you pulled back in September of 2013?
Yes, ma'am, I have.
And in listening to those calls, are they a fair and accurate depiction of the calls that you pulled back in September of 2013?
Yes, ma'am.
And did there appear to be any additions or deletions to those calls that were made, that you pulled back in September 2013?
No.
Your Honor, at this time, the state would like to show Detective Quinn Exhibit 175, which contains calls A through C. Your Honor, State's Exhibit 175A was already admitted yesterday. State's Exhibit, 175 Charlie Alpha was already admitted yesterday, Your Honor. What is State's Exhibit 175 Charlie Bravo is actually a duplication of Defense Exhibit 205. So they've already been admitted. The other three calls, Your Honor, will be new exhibits, which would be State's Exhibits 175 Charlie Delta Echo. Yes, 175 Charlie Alpha through Echo.
Yeah, sure.
Okay, so there seem to be jail calls that wasn't played during Mr. Bean's testimony, which apparently former Detective Quinn claims he have heard and will now testify about. Yeah.
They were all the calls on that. No, they are.
Dun, dun, dun.
Yes, probably do not. They would objection, but the prosecutor trying to figure out which jail call is more. One thing in addition to three, they tell us which ones they are.
I did identify two of the three that are the newer calls that have not been.
Well, if you only could identify 2 out of 3, that's not good enough to get all 3 in. Jesus Christ.
I identify one and I'll call it, for the purposes of this, the chicken call, because it stands out. She's talking about cooking fried chicken. The second call after that is a call where she's at the baseball game, and that's very identifiable. It is the third call that I advise that I will ask the court if we can take a brief break so I can just identify which call that is so they can know. But I've identified that 2 of the 3 calls.
Do you have any objections to the baseball or chicken call? Do you have your videos yet? Why do I need more time? You said, let you know. If the issue comes up. Okay, but do you have any specific objections to those 2 calls? Not the third one. We're going to need to take a break on. As I told you. I may have, may not. But you're going to tell me to let you know.
Why is this an argument? If she can't identify it, she has to. I mean, that's the rule of evidence. If she can't identify, then off it fucks.
Mr. Steele, please don't try to engage in conversation. You're not prepared. Because if you prepared, you would have told me. You invited this conversation. I did.
Oh, for frick's sake. No, Judge, you are in front of the jury. This is unprofessional from the judge. It's extremely easy for him to say, jury, please be excused, blah, 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 blah. But no, he starts yelling and calling Mr. Steele unprepared when it is the prosecution who can't identify the jail call. How is that being unprepared on Mr. Steele's? Jesus Christ.
I asked you if you were ready. If you were ready, you say, yes, Judge, I'm ready. I have to do those two off. Now, if you're not ready, then go ahead and tell me you're not ready, and we'll go ahead. I'll go ahead and we'll figure out something else to do. But if you have any other basis.
You never, ever do this against the defense in front of the jury. Never. Because this, with a jury, for them, this, they look at him, at his demeanor towards the parties. This is, I said it before, I will say it again, I will continue saying it. This judge is unfit for a trial of this magnitude. He should barely do traffic court. Barely.
Tell me.
You instructed me. I raised this already. You know exactly what I'm talking about.
No, I said,
Well, then we need to ask the jurors. Why do you expect the question?
How long is this third one? It's only,
They're all 15, 20 minutes.
Right, and I would say for the third call, Your Honor, really as it relates to this particular incident, there's only two relevant areas from 00 to 1 minute, and then 3 minutes and 50 seconds to 6:40.
It doesn't matter if you can't identify it, prosecutor. It has no relevance if it's just, it's just a short bit. Never mind, we have no idea where it came from and stuff. Jeez. And the judge is screaming at Mr. Steele about this?
Are the only relevant parts, I believe, for this particular matter.
Are you gonna want all of the third call to be played? I tell you what, how long is the third call?
So all the calls, Mr. Steele is correct. All the calls are approximately 15 minutes, and the state does intend to play all 5 calls.
Your time, as much time as you want. I'm sure refresh your memory.
No, I'm talking about third call.
But I need the court instructing me. I don't know why you're doing this. The court instructed me to help the court. That's what I'm doing. When it comes up, that's what you instructed. So I'm following what you asked me to do. Now you're acting like I'm not.
Yeah, here's the thing. This judge tells the defense, bring your objections when it is time for it. The defense has always tried to do this ahead of time. And the judge always defer it forward. He defers his ruling forward. Now, Mr. Steele is doing exactly what the judge said and brings it up when it's time for it. And the judge yells at him and calling him unprepared. This, as Gigi says, this is very prejudicial against the defendants.
I'm very.
All right, I tell you what, will 20 minutes be sufficient for you to review your drawings? All right, ladies and gentlemen, I'm gonna take 20 minutes and,
The very fact the judge had this done with the jury present, he should be kicked out of it. He should be kicked out of this case, of this trial.
all right, all right, ladies and gentlemen, please be seated. Your technical seat, okay? Yes, sir.
Hey, Your Honor,
Do I need to listen to the call?
you don't, the judge is great. When we come back, we'll just want to know a decision about the transcript, because we do have a transcript for the first call. And that was the one we gave them yesterday. So just a decision
Well, I
about,
thought you were gonna take more time for that because,
oh, they have not looked at it. Okay, never mind. Thank you, Your Honor.
all right, okay. We're in recess about 20 minutes.
I have a motion. I have a motion.
In regards to what, sir?
Your comment. I have a motion.
Okay, what's your motion?
Let's play this in normal speed.
Right.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay.
I have
Mr.
no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor, I
Mr.
need
Steele,
to
wait a
make
second.
this record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and
The only person delaying here is the judge. The only one. He's never on time. Not one actual trial day. This honorable judge has been on time. It is at least 30 minutes late. Every 15-minute break is at least 25 minutes long. Every lunch break is at least 90 minutes instead of an hour. He has half days where there should be full days. There are days where there is no court. He has weeks off, gives the jury a week off. He stopped the trial on the 19th of December before Christmas. He could have gone a few days more, but he chose not to. I mean, this judge, the reason this trial takes this long is because of the judge and the judge alone, not the defense.
elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now,
they do, and you still push it forward. Tells the defense, bring it up when it's time for it. And when they do, you yell at them. Why? Because you're a fucking retard.
I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So,
no, Judge. Rules of evidence. When the prosecution says we have 3 additional tapes to jail calls to play, we just can't identify one of them, then it's not evidence. It's not allowed in. You just, oh, fuck it. Play it anyway. Come here, prosecution. Give me a good old wank and we're all good. Ignore that. You fucktard. You incompetent bastard. Spineless piece of shit.
you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So
you, Judge, don't decide how the defense produces its defense. Their sole responsibility is towards their client. And you, Judge, are not allowing them to do it.
So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that.
Oh, fuck you. If it's not about embarrassing, why do you do it in front of the jury? Why don't you keep your head cool, turn to the jury? I need to address the court. never say I need to address the defense. I need to address the parties. Let them out. Then you can go be a fucking retard if you want to.
I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
That's not your job. You're there as the neutral part between the prosecution and the defense to make sure the law is followed. It's not your job to make it seamless. It's not your job to smooth it. It's not your job. If the prosecution wants to make complete asses of themselves, that's on them. You don't help them getting better, and you definitely don't help the prosecution making the defense look worse, which you are doing right now.
And the court is wrong. What
Okay,
happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay, which
let me finish.
Which call? Which call?
These calls, as you.
Okay, well then why aren't we taking them up beforehand?
The state just said, just now, these are the 3 additional calls that they want to introduce.
All right. Well, then here's your response. I'm going to give you an acceptable response.
I'm going to
Judge,
make
hold
my
on.
motion.
Huh?
I need to make my motion.
Judge, there's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this. Okay. I mean, like I told you, forewarned judge, a happy judge. All right. So had you just told me.
They try, and you won't let them, Your Honor. And they have filed pre-trial motions, which you deferred forward in time to when it's time in the trial. And then they do it, and then you yell at them. The sole reason this trial takes this long is because of you and nobody else. Glanville.
Up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they're trying to do.
Okay, well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at the chicken. They're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay?
Forget about
You are.
Judge, for fuck's sake, it has nothing to do with Mr. Steele. It's about his client, Mr. Williams. That is the person you are. Jesus Christ.
A grown professional advocate. I am a grown professional jurist. And people say things.
You're a person in a robe. Grown in years, maybe, mentally retarded.
To me, that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So,
as MG Law says, bullshit, judge. You are trying to prejudice the defense. It doesn't matter. Yeah, it's the defendant that matters. Instead, this judge is making this into a pissing contest against Attorney Steele, who intellectually knowledgeable, eons above this judge.
Sir, that's just the trial. That's just the trial of the case. Okay,
No,
but
that man's life is here.
and you
Realize it
and
affects him.
you're doing a fine job in representing him.
Well,
But you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me, because I have given you all this administrative time, all these breaks to go ahead and do this, and this is what delays the presentation.
What delays the presentation is the prosecution doing game, and you allowing it, Your Honor. She just told you she can't identify the third call. She has to identify the third call. And as Mr. Steele tries to tell you, Judge, in those calls is a third party who will not testify. Your Honor, needs to address that issue. And he won't. Instead, the judge is calling Mr. Steele unprepared. No, Your Honor. The only person besides the prosecution who shouldn't be in this courtroom is you. You yelled at the defense in front of the jury. You never do that. Never.
Of this case in front of the jury.
You know, if I would have done what the state did and I'm not poking anything at Ms. Hilton, you would have said to me, why didn't you share those calls with him before? What, you were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state didn't. I'm not poking fun because I can deal with it. But
Well,
the
you know
court
what?
then steps
But
in.
here's the problem.
You're
I
not
have
finished.
I have a problem with it, because here's at the end of the day, I got to listen to a 15-minute call.
You don't have to listen to anything.
But
You have to make a ruling
yes,
on it.
but I have to listen to it in order to make the ruling on those. And even if you said you've listened to the chicken call and the baseball call, and if you say there's other issues that come into play, it's better for us to take those things up before I ask for that jury. And I could have done that this morning. I could have done that at another point in time. So, I mean,
They try that all the time, Your Honor, and you still tell them, bring it up when it's time. All the time, this judge does that. And when they do, he acts like this.
Raised this issue to you, and I don't remember the date, but it was days ago. I raised it, and the court said, all right, understood, and we'll take that issue up when it comes. Now, what am I supposed to do? Okay, sit there and say no objection?
no,
Exactly right.
not at all. Not
I
at
said,
all.
Judge, it's an issue
Not
we
at
need
all.
to take up.
Not at all.
And in addition to that, today alone, and this happens, today alone, the state introduced 2 exhibits. I've never been given them before, ever. You know what I did? No problem. No problem. Because I think that's professional. One was a Google map. It needs to be clarified for the record that it was not done on September 11, 2013. And then a map with little dots with 0.4 miles. I've never seen before. But I didn't do anything, Your Honor. I want to move the case. But when the court, it gives me no pleasure in saying this. I believe that this honorable court is biased against Mr. Williams and or his counsel. And I ask you to consider recusing yourself, or don't do this again to me. This is inappropriate to me. I respect you, but what am I supposed to do? Sit there while you do this? I didn't do anything wrong. I did exactly what you teach me to do and the courts teach me to do.
All right.
But instead, no, I got to finish this. Then I get told to this court says by Prosecutor Love that I'm not being candid with the court and I'm misrepresenting because Mr. Bean never went to the hospital at Grady on September 11, 2013, and Ms. Love has a document on the desk to prove it. I sat right in front of Your Honor at the table, at the bench, and I said, I'd be careful what you say. That's not accurate. Ms. Love looked down on me and she said, it is accurate. You said, we'll take a break, figure it out. After the break, you didn't even bat an eye. Ms. Love said, yeah, I was totally wrong. Mr. Steele's right. He was taking a gravy. If I would have done that and called another member of the bar disingenuous, not truthful, no candor, and misrepresenting, you would have had me yelling in front of a jury. You did nothing. You didn't even ask Ms. Love to apologize. I don't want her apology. I don't care about Ms. Love, but I care about the court. And now if you can walk in someone else's shoes just for a minute and see what you're doing to Mr. Williams, because it's hurtful. I'm not the one wasting time. I'm here every day ready to go. I am not wasting the time. I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And that's to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever on
Mr.
these
Steele,
occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I had the responsibility to control the proceedings in this particular.
You don't control shit, you asshole. Nothing. You control nothing here. You don't even have control over yourself.
Circumstance. Sometimes things get kind of heated, and that's
when your asshole, is supposed to keep your head cool. Instead, you lash out like a fucking Karen on the defense. Now, you realized you were wrong. Your entire demeanor changed right then and there. You know you're wrong, but your fucked up pride is in the way. Am I still monitored? Oh, for Jesus Christ, how? Look at this. This is the current. How? All right, I'll take it. All right. Yeah, here's the thing. At the end of this stream, I won't be. I never am. I have to put in the review it, and in 50% of the case it goes green. In 50%, I'm still demonetized.
kind of that's the crucible and trial of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared, but
go back a few weeks, and this honorable judge said to Mr. Steele in open court he was being unprofessional. And he said it in front of the jury. Now he yells at him again, calling him unprepared on something that is completely proper. There is stuff in those recordings that the judge needs to have a ruling on. And if the prosecution had told the court in a timely manner, then you could have ruled on it. But the prosecution won't do it because they know they can walk all over you.
the things that I am bringing up to both of you, and I have fussed at both sides for this particular.
Once he has called out the prosecution. Once.
Issue of not being prepared in the sense of, and the only reason it it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken up. And sometimes if we've got to parse out all these things, as you can see right now, it takes time. And that's what I'm kind of concerned about, having been a jurist for a long time. So I understand that you're a zealous advocate. You in no way offend me by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the court's told you. And
Because you're wrong, you asshole. Because you're wrong. You're almost always wrong when it comes to the defense. When you make claims against the defense. And in a matter of hours, sometimes days, they show it to you that you did a bad ruling. You made a bad call. Once the state has really been told off. The other times when the judge tells the prosecution they are out of line, they keep talking, and eventually you buckle.
certainly could have explored other options. I didn't. So I'll tell you that much for what it's worth.
You
But-
allowed a member of the bar yesterday ask a witness who constantly is committing, respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and
If
but
I
sir,
would've-
that's
let me
sir,
finish.
sir, that's
I would have said that question about another member of the bar, prosecution. You would have come over the bench and said, "How dare you?" I sat there and I said, "Outrageous." You
Okay, but
denied the motion. I
but-
think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you, the appearance, if not the reality, is not good here. I'm being
What, to who?
to Mr. Williams.
Okay, but
Maybe to the others. Maybe
you're
there's
his
spillover
you're
effect.
his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that. They have the right to at least inquire about whether or not that
Not without basis. And they have to present that basis to you, Your Honor, before bringing it up in front of the jury. You allowed it in and you didn't even entertain the objection. You didn't care.
happened. Now, whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motives to misrepresent.
So
But
that never happened. No
But,
good
okay,
faith.
but I'm
Let
not
me
commenting.
finish.
I'm not commenting on that. That's for the jury. That's for the jury to decide.
I asked the question.
No. When the prosecution makes a claim that the defense have altered evidence in some case, they are, in all things relevant, accusing the defense of committing a crime. And you allowed the prosecution to say that out loud in court. You allowed it, Your Honor.
About a missing recording that I wasn't given of a statement made by Mr. Bean.
And
And
I-
you know what you told me?
And I keep
You know
telling
what
you,
you told me? You said, does the state have it? They said no. You said, nothing I can do. I tried to cross on it. You sustained an objection.
because it doesn't exist at this point in time. Now, if it exists at some point, I will. I told you I'd say it. One, I tell you, I apologize to you. And
Mr. Bean, in 2 recordings played in court, referenced talking to officers at the hospital. And you, Your Honor, still claim there is no evidence of any notes, any recordings from the hospital. even though it's clear in the recordings. Somebody from law enforcement talked to Mr. Bean at the hospital.
And two, I'll take corrective action
Honor.
against the party or the entity that failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective
But we don't.
beforehand.
No, we don't. That's
He
the whole thing
said
about
it.
it. You believe it. You honestly believe it. And
He
that's-
said it
and that's
in the
fine.
recording.
September 17th, 2013, on recording, Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall. He doesn't remember anything.
Here's the thing. That's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything. But if
Yes,
true,
you are.
that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm
And,
speaking with the
Your Honor,
court.
I object.
I'm
and I'd like to
speaking
level
with
an
the court.
objection.
Okay.
I'm
all right.
speaking
Let
with
him
the
finish,
court.
and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens
But
of a juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides the.
Then be the neutral part. At the moment, you act like a referee who has a stake in the game. And prosecutor, sit your ass down and shut the fuck up.
Those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that
It
is
has nothing
certainly
to do with a throw war.
no. But I mean, it's your ability as an advocate. I told you before. That's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I'm not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're very good.
That snippet in time was in front of the jury. And it's not a snippet. You just don't do that. You just don't do that. And about law and crime, look at what they write up here. Young thug's attorney throws tantrum after judge says he's unprepared. This is not a tantrum. This is an attorney making valid claims to the court. Whoever is on law and crime making these headlines, go fuck yourself into a deep hole. You absolute fucktwat.
Attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that my job as the referee is to give you a fair trial, and that's what I'm going to do.
And how do you do that, Judge? By yelling at the defense in front of the jury. When the clear option is, when you are about to lose it, you just 5-minute break and fuck off. Come back. The jury is already out the room. And now you can have this shouting match. But you do it in front of the jury. That's not making it fair. That is biased.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared because that.
So when the jury comes back, yell at the exact same way towards the prosecution, or apologize in front of the jury to Mr. Steele. That's how you rectify it.
I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without.
Oh,
telling
I've
jurors-
taken, I think I've taken Miss Love and Miss Hilton and her colleagues to task many times.
No, I've heard.
No, ho, fuck you. Oh, no, Judge. Once. Every other time you do it with the jury out. When you try to put your foot down towards the prosecution, they keep nagging you until you buckle. And you buckle every damn time.
You yell at me.
I've taken them to task as well.
I've heard you say to her, "Stop interrupting me." Answer
Oh,
my
that's
questions."
taking them to
But
task.
The jurors never heard that, ever. So I asked for a continuing recusal motion, and I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, when you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny them. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do, and I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now,
I don't
Ms.
think
Love.
I don't think it's a fair forum for Mr. Williams. And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through the, I told you all, both sides have told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Well, I made this motion whenever I made it, and I raised it, and you said we'll get to it.
Yeah, but it's
the only reason. I mean, we are trial day 46 here. We should be at trial day 27 or 28 because 9 to 6. Okay, that's 1 hour lunch. Okay, 8 hours. 2 15-minute breaks, 7.5 hours. Half an hour to get prepared before, so starts 9:30, 7.5 hours. The average trial day with testimony or presentation of evidence is under 3 hours because there are half days. Some days are just an hour and a half long. We should be at day 27 or 28. Yes, Angela says, well, that's your fucking job, Judge. You have to rule on things. And if the defense makes motions because of... What do you expect them to do, Your Honor? Sit down, shut up, and hope for the best? No. They advocate for their client. They advocate for their client. And you, Judge, are making it way too hard for them to do that by your inability to make timely rulings on stuff that you clearly can make immediate rulings on.
timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it kind of so I could kind of take it at that point in time?
Your Honor, for fuck's sake, the prosecution just said, I want to enter these 3 new jailhouse calls. I can't identify one of them. When is Mr. Steele supposed to know that would happen? Yesterday? A week ago? No, he just found that out. So he makes a motion.
None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right. Okay. All right. Ms. Love?
Your Honor, just the state was asked that the court deny the motion for mistrial. The state has provided to the defense these jail calls. We have actually requested more than once what portions are objectionable, what portions do they not want us to play. We have sent.
This is Ms. Love trying to dictate to the court what the defense is allowed to do. Fuck you, Ms. Love.
them to the defense in a format that they can listen to them offline without having to have the actual CDN. We have had them converted for them. The objection that we got initially was put to the call that Mr. Steele essentially put in by playing the recording of the interview that Detective Quinn did with Adrian Bean. And the whole
which he got through your discovery, Miss Love. He didn't invent that. He didn't go into the evidence locker and pull that out. He got it because you have to give it to him. He's not a fortune teller. He doesn't know from day to day what the fuck you're going to present to the court.
whole jail recording that was played during that interview was State's Exhibit 175 Charlie Alpha. So the portion that they initially said that they objected to, that third party portion, and we had a motion on it, they actually introduced by playing the interview with Detective Quinn. I have said to them, I'm certain that Ms. Hilton has communicated with them via email that we are using the jail calls. And I know I personally have asked.
You still have to proffer it to the court. And Miss Other Lady said to the judge, I can't identify one of these. Louis Thomas asked, are these prosecutors malicious or incompetent? Both. They have a shit case, complete garbage, in my opinion. Should never have gone to trial at all. They still do because it buys them votes. Has nothing to do with justice. If the district attorney's office in Fulton County were about bringing justice, there are 20,000 cases waiting in the docket. This trial has been going on since, well, when was it? Late November. Every day in court, in this trial, every day, between 4 and 8 cases could have been handled. If this trial takes 200 days, that's between 800 and 1,600 cases that could have been solved in this courtroom. If this trial takes 400 days, that's between 1,600 and 3,200 cases that could have been solved in court. The district attorney's office is using this for one case, and it's a shit case.
What do you object to? So at this point, I'm not certain why there is this motion. I object to the language that is used. I'll die if the court does this, Your Honor. The court is well aware of the times that the state has received reprimand, both in front of and out of the presence of the jury. I'm not certain where that's coming from. I would ask that the court, of course, the court has already ruled, but the notion that there's a bias, I'm not certain where that's coming from.
Fill up my
the
coffee.
amount of tongue lashings we've received from the court on the state side. So I would just object to the defendant being granted a mistrial. And I state for the record that the portion that they identified for us that they objected to regarding the jail calls was entered through their cross-examination of the witness, Adrian Bean. Thank you.
What about the sealed document Mr. Steele is raised or made an issue of at this point?
With relation to the sealed document, that was a memorandum of the interaction that a lieutenant with the district attorney's office had with a party as it relates to Mr. Steele's interaction with that party, unsolicited. After walking out from the stand, that party made comments to members of the district attorney's office. The state asked that party, and we did not assume facts that were not in evidence. We asked, unlike the question, why did you do this? Or why did you do that? Which would assume facts that were not in evidence. We asked the open-ended question with a good faith basis for doing so, and with an ability to impeach if there was a denial.
Yeah, I'm seeing, can the district attorney be impeached? This is the assistant district attorney. Her boss is Fannie Willis. And nothing in that Fulton County District Attorney's office is ethical, in my opinion. So, no, nothing will happen to Miss Love.
Of having sex.
Oh, and by the way, Judge Glanville is chief judge in Fulton County. He is the boss of the other judges, more or less. He's the chief judge.
So we didn't make that up out of whole cloth. We wanted to make certain that all parties on the defense side had that random. And frankly, Your Honor, I think it is improper for anyone, for certainly any member of the bar, to stand up during the cross-examination, direct examination, and offer testimony essentially to a jury. So for Mr. Steele.
Because you were being a cunt, Miss Love.
Stand up in the middle of my redirect of Adrian Bean and to say that did not occur, or preposterous, or outlandish.
But what is that? How is that any different from what you are doing every day in this trial, Miss Love?
Is completely improper, disrespectful. The state has done nothing of the sort. And we would ask that Mr. Steele be reprimanded for doing so. And the court rightly did so. And to have him ask for an apology after he has been blatantly, improperly acting before the jury.
Remember, Miss Love, when you said Mr. Bean never been to the hospital. When you said in front of the jury that Mr. Steele more or less was a lying liar who lies in front of the jury. Then they had a break, the week break. And when they came back, she pretended it never happened. And just, okay, he was at the hospital, yada, yada, yada. But he never talked to a cop. Don't mind if I lied to the court, like the bitch-ass cunt I am. Just let us move on and pretend it never happened. You lied to the judge. You lied to the court, Miss Love. You lied because you thought you could get away with it. You were caught lying and nothing happened to you.
I don't know what else I could say. I would just ask that the court admonish counsel for testifying during trial. I have given the state, the court, the basis for the questions that I've asked. And I've never asked a question that assumes facts that are not in evidence. Unlike the question, why did you? Did you know that? Do you recall that? I didn't phrase my questions like that because I know not to do that. And I'm not going to do that. And I don't want to improperly give the jury an impression of something that exists or that will be shown that I can't show them. So there's a real clear distinction in what Mr. Steele asked, implying, why did you give a statement at the hospital? And he keeps conflating what it is that is objectionable. He keeps asserting something so that everybody in the ethos is asking, oh, where is this interview?
We all are, because we heard the statement from Mr. Bean in 2 different recordings, implying and saying out loud he was interviewed or talked to cops at the hospital. So yeah, I will say it out loud. There was recording, there was notes from detectives, and I think they destroyed it. And you, Miss Love, probably knows this, and you are helping them covering it up. Sue me, bitch.
This recording. He's never seen one. He doesn't have a good faith basis asking for one. And yet he continues to put that question out there so that everyone in the universe has this idea, oh, the state is hiding something. Oh, the state destroyed evidence. Again, they sat there for a whole day asking witnesses about the destruction of evidence. There was no evidence that anybody destroyed any evidence, yet they stood there a whole day.
Except that Mr. Bean said he lied to the prior cops. And the only time he could have been interviewed was at the hospital. Ta fucking da.
And ask someone about that. And then he asks a witness on the stand under the guise of impeaching him, Do you recall that? Or didn't this happen? Or can you explain why the state would delete?
I don't want to listen to this bitch ass going on. Let's move ahead to Mr. Shard. Okay, they're going back to
which of the 8 calls this is, then the state has no problem to do that. But to say that they just received the calls or they just learned about the calls, that is not true. They've known about.
that is complete misrepresentation. They didn't know which of the calls you were going to present, especially since you couldn't even yourself identify one of them.
About the calls. Now, for me to identify this last call, I can do that, and I'm going to look for the email, or it might have been.
I can do that. You fucking have to do that. Otherwise, it's not admissible. That's the rules of presenting evidence into court.
Conversation in court, but when they ask what media will you use, I think I said we're going to use all the jail calls, and we're not actually using all the jail calls. We're going to use 5 of them.
Aussie Tank asked, how is this even legal? It isn't. I haven't, in every type of trial setting I've been covering, and what they are doing, the misrepresentation, knowingly lying to the court. Ethically, this prosecution should be disbarred, all of them. Yeah, exactly. As MD law says, you can do it. You are required to do it.
So this is not new evidence for defense counsel.
Sir.
About and maybe this will give a path moving forward that's a little bit more efficient, hopefully. There are thousands of jail calls in this case. So,
Your Honor,
hold on.
not for this case, for X 5 to 7 specifically.
Okay, there are thousands of jail calls for this case. So they gave about 10, 12, however many jail calls. They're saying, I'm not going to dispute that. I don't have my computer in front of me, but it seems very inefficient to me that we're going to litigate, and you want us, the defense, to raise our objections to thousands or even 12 jail calls and suggest redactions for all these jail calls.
But when did you get the jail calls? When did they tell you? Didn't they tell you like within a week or two, like I asked before, that they were going to use these calls?
So, Your Honor, they just identified one is the chicken call. That's not how they are in discovery. So there's a cross-reference number. So we need to know exactly what call by the cross-reference number in discovery. There's nothing labeled chicken call. There's nothing.
All right, but listen, is there a certain number of calls for this particular act or acts? I mean, yes or no?
I can't, I don't have the email in front of me. So
yes, okay. So there's how many? 8, 10 calls? How many?
Your Honor, there's actually 8 calls, and 2 of them were duplicates. And so in the email that I broke down,
so in preparation, you know that if this particular act, which we've been dealing with for weeks, you only got about 12 calls to listen to, right?
You absolute
so
fucking
you would
idiot,
like us
Your
to
Honor.
proactively state our objections for every call and litigate, because they're not using every call.
Only if it becomes an issue, because if you all work it out, that's fine.
It just became an issue because they called it the chicken call. That's not how you do it. It became an issue the moment she said, we are calling one of them the chicken call and the other one the fucktard call, and the third, we can't identify it. It became an issue, and you yelled at the defense for objecting to it. You absolute moron.
I don't have any issue with that. But if it's going to be an issue, then I need to be able to vet it. I got to listen to the call. I got to listen to the evidentiary basis as to why it should be admitted.
They just presented it. They just presented to the court 3 jailhouse calls out of 8, which they call something that's not in discovery. One of them, they can't tell which one it is. Well, should the defense take a wild guess? Okay, guys, we have just about a 20% chance of guessing this right. No.
Not admitted. That just gives me time to do that. And if you say it's only going to take about 15 minutes or whatever, well, it may take longer than that. You see how long we've been out dealing with this issue. So that's what I mean by forewarned judge is a happy judge. So if we could
How can they forewarn you when they don't know that the prosecution is mislabeling jailhouse calls and tries to enter unidentified jailhouse calls? How? How?
take it up and I don't have to either have them sit in their headquarters, it's better for all of you.
I do not dispute anything you're saying, Your Honor. All I'm doing is suggesting that if last night or yesterday we were told tomorrow we plan on playing this call and it wasn't the chicken call or the whatever call, it was
Baseball.
whatever the number is in the discovery or on the email, then we would certainly, I would say it would be on us. But that's not exactly what happened. I just want Your Honor, and I'm not trying to, I really like Ms. Hilton a lot, so I'm not even trying to argue with her or say she's done anything wrong. It's just, I think if we know a little bit in advance and it's not just, oh, the chicken call, then we would be in a better position to lodge our objections to you. Because right now they are, I assume they're getting the cross-reference numbers, so then I can bring those numbers to the defense table so we can pull up the exact calls that they want us to review. So that's kind of, I just wanted Your Honor to understand it's not as simple as just we didn't listen to the chicken call.
Your Honor, if I may respond briefly, Mr. Williams, I believe, filed a motion in limine number 40. That was the only motion in limine that we had as it related to a jail call. And that was objecting to the third-party information contained in jail call number 175, Charlie Alpha, again, that Mr. Steele introduced by playing the interview of that Detective Quinn conducted with Adrian B. So we have again turned over the 8. We can specifically give track 1, 2, 3, 4, 5 of CD 1, 2, or 3. We can give that information to them. The way that Ms. Hilton and
So why didn't you, Miss Love? You just informed the court. This is what we could have done. So why didn't you? Come on, Judge. Yell at them. Yell at them for not presenting this to the defense in a timely manner so they could make their objections in a timely manner. Come on, Judge. Yell at the prosecution right now.
Atkins noted and time hacked each of these calls.
What a shocker. He just sits there like a sack of potato.
Identified as such, but there were 8 calls. There's no other call within which the information she has spoken to the court and described the call using. There's no other call that has that information out of the only 8. So I'm not certain the reason for the reference to thousands of jail calls in this particular context. But, Your Honor, we have 8 jail calls here. We turned over. We've asked, what do you?
Then why didn't you use the language in discovery? These are the 8 jail calls. Okay. 2 has already been presented in court. Okay. That leaves 6. We are using half of them. Guess which ones? No. And the reason they do this is because they know they can. They have figured out that if they do this, the defense will object and the judge will become an asshole about it towards the defense. Not the prosecution who made this situation happen. No, he yells at the defense for reacting on the prosecution's misconduct.
Object to, and the only thing that we've gotten was motion limiting number 40 from defendant Williams.
All right. Anything else before we recess? I still gotta allow you to listen to the phone calls.
The facts got lost. The accurate facts, I've listened to all the calls, the relevant calls. I've listened to them all. I know what the chicken call is. I know what the baseball call is. The issue is there's third parties making statements of fact, introducing statement of fact. We argued this. The state's position was it's non-hearsay because it goes to the effect of Mr. Bean, who will be a witness. I dispute that. I believe it's hearsay. That was the issue. You said, we'll take it up.
Yeah.
That's it. I'm not saying I don't understand the parameters. The only call that's the issue is, Madam President, District Attorney Hilton said, I don't remember what the third call is. I'll let you know on a break. I was comfortable with that. But I just want you, before these jail calls are being played, to make a ruling, because I waive it.
I need to hear the call, though.
Exactly.
Okay.
That's what, that was my objection. That was it. And I did it in a manner that I thought was appropriate to say that we raised it. Your Honor, court told me to let you know. And then we got here.
All right. All right, N105?
Yes, sir.
Okay, all right. They're both denied. I'll note your objection and the continuing objection, Mr. Harvey. All right, we're gonna take, did you have something? Sir? Okay, we're gonna take 15 minutes so you can listen to the call, and we'll come back at that point in time, okay? All right, we're in recess.
And they're on a break. And yeah. Oh. And for you who are completely new to this trial, this has happened before during pre-trial motions. Not as severe as this, but it's happening all throughout this entire trial. So if you wonder, oh, why is Nick yelling at the judge and yelling and calling the prosecution names? Because I started covering this pile of manure in May of 2023. I have currently, let's see here, 65 streams on the young Thug RICO trial. And I probably haven't all of them in my streams in that because I forgot about putting them into a playlist. So probably closer to 80 streams about this young Thug trial. I'm calling out the prosecution and the judge because they have done this the entire time. Absolute garbage, absolute unprofessionalism, absolute misconduct. If this judge actually applied the rules, the law, this case would never have gone to trial, in my opinion. And as MD Law says, that's one reason I haven't been following this trial as much. I know the judge is incompetent to preside over it, and the state is going to cheat their way to a conviction. I'm afraid of that. I'm in the hopes that the jury will see through all of this, take 45 minutes, and then acquit. Just to say the final off you fuck to both the prosecution and the judge. And then they have to answer to their voters why they have spent in if this trial goes the entire year of 2024, this trial with pre-trial and everything will have cost Fulton County taxpayers over $10 million. One case. And then you still have the former President Trump RICO case that is ongoing, pre-trial ongoing, where the claim is that, yeah, we will get this to trial and get it to the jury before the election. Really? No. Oh, and by the way, at the beginning, there were 12 jurors and 4 alternates. No, 12 jurors and 6 alternates. 18 in total. As of about a couple of weeks ago, end of February, there were confirmed 2 jurors down. One because of illness, and one because she moved out of the county. But I saw a motion regarding this delay and stuff like that.
Yes, please.
I saw a motion from the lawyer of Mr. Kendrick that there are down to 15 jurors. So somewhere along the lines, it seems like a third juror has been excused. I don't know when that happened, which means they are down to 12 jurors and 3 alternates. And they may have almost a year left of this trial. And the moment they are down to 12 euros, the judge needs to make a call about a mistrial. Because you can't have this trial without 12 euros. And here, statistically, shit will happen. Accidents, illnesses, moving out, anything can happen. And yeah. And these jurors were told when they were seated in November last year that this trial would be 6 months tops. We are 3.5 months in, more than 3.5 months in, and the prosecution isn't. They have only called 40 out of their 400 witnesses that is in their list. There used to be 700, but the judge made them trim it down to 400. We're all in about 8 days. We are 4 months into this trial. And on average, the prosecution has called 10 witnesses per month. If they keep that average, we will be here till 2027. Because that would mean 10 months more for the prosecution's case in chief alone. Then you have the defense case in chief. Then you have the prosecution's rebuttal to the defense case in chief. Yeah. And this with only 3 alternates left.
This is in respect.
Well, let's just say I'm not worried I will run out of content anytime soon. But here's the thing. If this becomes a mistrial, the prosecution will just recharge these defendants and they will remain in jail. Because this judge is incompetent, a moron, and shouldn't be anywhere near a courtroom, in my opinion. And because of him, 6 defendants who has been in jail for almost 2 years now will be sent back to jail. The prosecution will refile. They have, I think, 70 or 90 days or something like that to start the trial. And start the trial doesn't mean sit down and start presenting your case. No, that is to begin jury selection. The start of the trial is jury selection. It took them almost 11 months last time to get these 18 jurors, 12 and 6 alternates. 11 months.
Thank you. Objection.
Yes, please. This is in respect to states 175 Delta.
Yes, Your Honor. I'm going to share and play the call.
Excuse me.
But Your Honor, I believe Mr. Steele has an objection to
Yeah. The prosecution told the court they were ready for trial in November of 2022. They started jury selection in January of 2023. The trial started late November 2023. It took them 11 months to get a jury.
portion of 175C, Charlie.
So
Charlie Delta, I'm
from
sorry.
your discussion, is it Charlie Delta or Charlie?
Charlie, 175 Charlie.
All right, what is it? Is it Charlie
Charlie.
Delta?
The
What is
first objection he has is to Charlie.
Okay, and
then-
how long is Charlie?
The entire call is about 15 minutes, but
Okay, and what specifically is Mr. Steele objecting to?
the portion of the call is timestamped 10:35 through 10:56.
Okay,
And the state intends to play that.
he has no specific objection as to.
Yes, Your Honor.
Okay, all right, let's play that first.
And do you mind if I sit, Your Honor?
No, not at all. Mr. Steele, is that correct? States Charlie 10:35 to 10:56?
Just for the record, that should have been the entirety of what we just observed before the break and everything. Mr. Steele would have put in his objection, Your Honor. We believe. Okay, what's the objection? There needs to be redactions because of hearsay. Okay, let's have a discussion about this. Jury, please leave. And this would have happened. Instead, we know what happened. The judge was becoming a male Karen.
That is correct. The state said they're playing from 000 through 125. I do not oppose. The state, assuming the foundation can be laid, the state then wants to play 1039 to 1330, but I do oppose an objection. I believe it starts at 1035 through 1056.
Okay,
That is correct.
all right. Let's play it. Let me hear it.
Hello, this is a prepaid. And Your Honor, I'm going to start it from the 10:39 to 13:30 portion of it. Well, Your Honor, I'm going to start at 10:31.
And I don't ask this a lot, but if you have a few bucks to spare for this old labor law stuff, doing all this commentary, if you enjoy it, I wouldn't mind if you became a member or, just to sponsor the channel, just a tiny little bit. I would really appreciate it. The occasional super chat and gifted memberships, that's what keeps this channel afloat. Cover all the costs and gives a little surplus so I can get to Matsuri in August in Houston. And in August, I will make a road trip from Houston via Atlanta, Delphi, and up to Michigan. I would greatly appreciate if you could help me by sponsoring that by making a few occasional donations. Oh, Lama Big Bang became a member. Thank you so much. Thank you. That's very, very nice of you. You now have access to all my members-only content. Yay! And for you who wonder, that's $3 a month becoming a member. Thank you. Thank you so much. Oh, yeah. Oh, I forgot. I have here. Dun, dun, dun! Yeah, that was my grifting time. Now, let's see here. On Friday, tomorrow, we will be playing What the Hales. Final part of, I think, third or fourth hearing in the What the Hales case. And I will take a shot of some boozy stuff for every time the judge says in the totality of the circumstances. And that's another clusterfuck of a case. Yeah, okay, grifting time over. Let's continue.
It is what it is.
Yeah. He said, well, like, $150. He probably $150. Well, what a lady, y'all just say y'all didn't get late, so what about that? Oh, God, there's so much going on. I don't know what happened. I just don't know what happened.
What?
Yeah, y'all didn't play. Okay.
Did anyone hear what was said in? Did anyone hear what she said? Thank you so much, Nana Misty, for your $5 super chat. Love your show, Nicholas. Thank you so much. I do my best. I'm trying, Your Honor. I'm trying. Thank you so much. And about the question, if the judges in Fulton County are elected, yes, they are, all of them. So is the district attorney. And I saw somebody saying Galveston. I've been to Galveston. I was in Houston in 1996, and we went down in April, and we went down to Galveston. They have this huge aquarium of sorts with the parrots and fish and stuff, and so we went there. And I also, me, my dad, and a bunch of mates went there. We stayed at a motel at NASA Road. Interesting breakfast with burnt coffee and donuts, and yeah, we had lots of fun. We went through the America Mall, I think it's named, in the center of Houston. Yeah, we had lots of fun. Then I attempted to drive in Houston. We had to call a cab to direct us back to the motel at NASA Road. So the cab driver drove in front of us so we could find our ways back. All right, back to the trial.
Plus, you got check on in their car, charges in their car, all this shit in their car. You have a check sheet, because them niggas out, man, be done stole all type of shit. And I don't even know what umbrella I got. Well, you don't even know what that nigga buck boy had. I ain't give him that. I know I'm gonna lay my pocket.
I don't know. They said no. They said about they told the whole story. Goddamn book like hell on the play there. Them hoes said everything.
Well,
How they were going. The little two hoes who be sitting down with y'all last, who with the other little hoes. Now we went grocery shopping, and he gonna come back and cook the chicken and I was hype on shit. Like, really, bitch? Oh my God.
Translation, please. I have no idea what was just said on that recording. Does anybody speak jive?
They went to look for it. They were going, I mean, the whole story. The whole fucking story. Like, you what you do this your family over here?
Dude.
Like, you supposed to be at you. He told the cook some chicken and...
Don't fuck with them on their own. I told them I know how to cook the chicken, but I told them off the rip that Buck and them gonna go and cook their own food. Buck know how to cook. Buck them gonna go to the Blue and cook their food. I wasn't going to cook them a goddamn thing.
I hope I'm wrong, but did they say something about butt cooking chicken? Let's just play it.
That was Buck told us people gonna cook the food, and they lied.
Yeah, you supposed to be confident and fried chicken and all that shit.
Look at my cup, baby. I already had 8 things on, so I don't even off that. I ate some Mickey D. Them folks down there, somebody, they were hungry with Thug. That girl said she had some food stuff. They told me going to the store. I told them to go ahead and go to the store. They went to the store. They come back. Somebody goddamn, it's a lick around the corner. Goddamn, that nigga name goddamn Red Man got some money. So I said, shit, get the skateboard car then. Goddamn, y'all take the skateboard car. That thing, you know, I like, fuck that shit. The nigga told me about 15, 20,000. I like, fuck that shit. I'm finna get the car and drive. That was it. That's the only time I drove out yesterday. I didn't go nowhere. I ain't been no grocery shopping with no motherfucking body. I don't know what the fuck they do. He was just say shit anyway. What the fuck they don't know folks? Them kids be lying like a motherfucker. Who would even make up something like that? I ain't even said no shit like that. I ain't never y'all. I sell food. When I go out there and let somebody get something to eat, I eat buck. Buck go out there and cook your own food. Rick, go out there and cook your own food. Whoever working, go up there and cook your own food. Hey, y'all cook your own food. I'm not going up there cooking there for nobody, man.
Yeah, so we was out there yesterday when they showed it out there. Your child came and cut the goddamn lights off on the phone. So, but they still around there, like, literally today, they been around there all day. Like, I said, boy, you need to go put them folks out their house. You need to go put them out, yeah.
Mayor, I'm sorry, we went past the 13.
Obviously.
Mark. I apologize. So, Your Honor,
All right, who is speaking in States 175 Charlie?
sure, Your Honor, the two callers, well, the caller is Adrian Bean, and he is speaking with his wife, Courtney Bean. The portion in which Mr. Steele is objected to is the portion from 1035 to 1056. Specifically, I'll just replay that particular portion so you can hear that.
All right.
So he can't say.
And I'm going to start it at 1031 and I'll stop it at 1056.
It is what it is.
Yeah. Got Thug come out, he said, well, like, I mean, bro, like, us $150. He bought the lean with the $150. Well, what a lean that y'all just say, y'all didn't get lean, so what about it? Oh, so there's so much going on. I don't know what happened. I just don't know what happened. Yeah, y'all didn't play.
And I think that ends the portion in which Mr. Steele is objecting to.
Okay, Mr. Steele, what's your basis, sir?
Oh, how cordial the judge is all of a sudden. I hope Mr. Steele can tell us what was actually said.
Your Honor, it is a third party speaking. I believe the voice is Courtney Bean. That is my belief. And she is saying outside of the court, it's being introduced for the truth of the matter asserted, that Jeffrey Williams, known as Thug in that call, said that they was worried about the lien, was getting the lien. I cannot confront or cross-examine Courtney Bean. And therefore, I have, as I did previously in writing, it's a third party, it's a non-testifying third party.
Is Ms. Bean coming to testify?
No, Your Honor, she's not.
Okay. Is she otherwise not available?
How about that, Judge? If you hadn't been such a douchebag, this would have been the entirety.
Or is she unamenable from appearing in court, or is she deceased, or what?
No, Your Honor. The state believes that this portion can be called because Mr. Steele and playing both the interview with Adrian Bean as well as the jail call, the second jail call with Adrian Bean, in which they talk about this lean conversation. It derived from these jail calls. So when you heard the interview in which Detective Quinn is talking about the lien, or they're talking about the lien within that interview that was introduced by defense counsel, they've opened the doors for us to give context with this call as to what they're talking about.
So you're saying it's not for the truth of the matter asserted?
It is not being offered for the truth of the matter asserted in this case. And this whole conversation about the lien has already been introduced. This is what was introduced through the entire interview. So this is not being offered for the truth of the matter asserted.
What was that exhibit?
I believe that was
Bullshit.
it was the State's Exhibit 176C, 175C, Charlie.
Okay.
But we did not object to Mr. Steele.
And as people in the chat are saying, then why didn't you play this while Mr. Bean was on the stand? Why do you want to play this with Detective Quinn? Just because he claims he heard this specific jail call? That's not enough. MG Law says, nope, it's inadmissible. It is being introduced for the truth of the matter asserted, and you have no one to authenticate and sponsor it. Yeah. But, newsflash, this is Judge Asshole. This is misconduct. There's no way to know if they are going to apply actual law to it.
Introducing that entire recording, but Mr. Steele's the one who introduced it.
Okay. So 175 Charles has already been introduced, and
Yes.
it already has this portion of the tape in it.
Yes, the talking about the lien and
This should have been called when Mr. Bean was on the stand. Problem here is that Mr. Bean has been permanently excused. So they can't call him back for this. And I assume that's the reason why the prosecution did just that, so that they could play it with Mr. Quinn on the stand instead. That's a foul tactic.
all of that. Yes, it's already before the.
Okay.
I don't believe, may I have a second?
Yes, sir.
I think he asked you, is that jail recording, that section already in evidence?
No, sorry, not the jail call, just the context of the conversation. Excuse me. So let me be clear. Not the jail call. This jail call is not introduced, but the context of the lien conversation is already introduced. And we're not offering this for the truth of the matter asserted. This is giving context to all of that conversation that they were having within that interview with that Adrian Bean and Detective Quinn, that interview that they were having.
May I respond?
Yeah, sure.
Mr. Bean is interviewed by Detective Quinn. It's 176 state exhibit. And if I'm wrong, just 156, I believe, state exhibit.
The interview?
Yeah.
175.
Sorry, 175. This call is not played to my memory. It may be referenced, but Adrian Bean tells Detective Quinn that he was buying lien and he was robbed. You don't need to complete the story a third-party statement about lien. In fact, in these jail calls, Mr. Bean again says, I was buying lien. So the state is introducing now from a third-party non-testifying Thug. Thug is interested in the lien or worried about the lien. That I cannot confront. That is an out-of-court statement, and it is offered for the truth of the matter asserted. And there's other evidence. It is not, I didn't open the door to this call. It was already in evidence that Mr. Bean said to Detective Quinn himself, he was there to purchase lien.
Yeah, remember what the remember the name of the evidence. State's evidence 175. Not the defense evidence. The state's evidence.
All right. Okay. Ms. Hilton or Ms. Love, is Courtney Bean is Mr. Bean's spouse, correct?
Yes, Your Honor.
All right, and she's not going to testify?
She is not testifying. Your
Okay.
Honor.
If she's not going to testify, go ahead, I'm sorry.
I'm gonna say additionally, Your Honor, a few things.
Oh, you fucktard. The judge was about to rule. The prosecution notices it. Boom! Let's distract him with word salad. Look over here, Your Honor. Look over here. Ba, 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 ba. Just admit it. Ba, 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 ba. We want it. Ba, 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 ba. I will give you a wanky. Ba, 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 ba.
In addition to it bring context, it's also effect on the list.
Here's the thing. Mr. Steele objected, made an oral argument. The state responded. Mr. Steele asked, may I address this? Yes, you may. He addressed it. All sat down. It was about the judge to make the ruling based on what was actually said. The prosecution, without asking permission, starts babbling. That so disrespectful.
Listener, as well as I want to cite the court to Jones v.
Which listener?
Adrian Bean, because he's commenting on what his wife is telling him in this case. And I'm going to direct the court to Jones v. State, which is 339 Georgia at.
Why didn't you bring this up when you had the chance? Here's the thing. In my opinion, Mr. Steele objects, makes his oral argument. She makes her reply. Mr. Steele gets the last word. Now it's done. Sit down, shut up. But this judge has no spine.
9-5.
95?
Sure, it's 339.
Is it 95?
339 Georgia,
Okay.
Georgia at 95, and it's a 2016 case.
Yeah. Yeah, and as you in the chat say here, this should have been introduced during Mr. Bean's testimony. That was the proper
And
place and time.
Next is going to be at
That is long gone.
101,
Okay, so, yeah. Oh, you said it's at 1. Let me just find it.
Penn site 101.
They're referring to his client, and he and his wife have basically inserted his client in this particular in this particular conversation.
So that's exactly what's happening in Jones v. State. So the informant.
Different because it's in Jones you got an informant and then you got a drug sale. So those particular statements were made for the context of what a G was, a gram of heroin. So,
But the issue here in this case, Your Honor, was that the recording, they did not want the recording to come in, the entirety of the phone call itself when the informant was not testifying. And Mr. Steele's argument is that because Courtney Bean is not testifying, therefore the call cannot be played. But in Jones, what Jones is saying is, although the informant was not called to testify, that recording could still be played. And it specifically says, in admitting the recording, the trial court ruled that the informant's statements were admissible to provide context for Jones' responses.
what statements are you trying to place in context?
I'm placing in Bean's context. So remember, him and his wife are having a conversation. So things that Bean is saying on this call have to be placed in context so that the jurors understand why he's responding the way that he is responding. And that is why, based upon what his wife is telling him. So
Well, what's he saying about Thug or that on this call? What's
they're
he saying
talking about the lien and what was happening as a part of what happened on September 11, 2013. So so her conversation is all in reference to what happened on September 11. Remember, at this point in time, Your Honor, Mr. Bean is in jail after being going to the hospital and has gone back to jail. So they're on the call right now discussing what happened on September 11, 2013. And this is after a number of calls. So, Your Honor, and put it really in context, this is the third call that happens after Stacey Exhibit 175 C that was entered into yesterday.
So if the lien has been debated in another Yale call, then then this is just compound in order to get the name Thug introduced. No. And it should have been introduced with Mr. Bean on the stand. Here's the thing. The prosecution, when they went home or anything in the pause, Mr. Bean, let's permanently excuse him so we can't call him back. Then the judge might allow us to play this to Detective Quinn. This is tactics. Knowingly, they would introduce this shows to permanently excuse Mr. Bean from testifying. That should be the ruling. No, if this was about to be allowed, then this should have been called during Mr. Bean's testimony. You fucked up. Now off that piece of evidence, fuck. As MD Law says, if it's going to present, if it is going to present sense impression or impression on being or wife, and the wife is not available, then it was required to be pre-introduced through being. Not a detective who we don't know if he listened to this call or not. He cannot validate. He cannot introduce this piece of evidence.
As well as state defense exhibit 205. And then this call is a part of those jail calls that all came in right between September 11th and September 12th, September 12th and September 13th, Your Honor. And so all of these calls are talking specifically about what occurred on September 11th, 2013. And Mr. Steele, again, has already introduced what Thug said about the lien. All that came in during that first call that has a third party individual. So this information about Thug.
No, Mr. Steele hasn't introduced anything of what Thug said. This is Mr. Bean's wife making claims about Thug. That's not only hearsay, that is double hearsay. That's 2 steps removed.
In the lien and all of that is already, one, in evidence because of the other call, but 2, this is a jail call that is not part and parcel, but that came in after those 2 calls that we've already heard. So again, this is all putting those calls into context.
And you had knowledge of this during Mr. Bean's testimony, and you actively chose to not introduce it then, even though you had the knowledge and the capability of getting that piece of jailhouse recording in through Mr. Bean. And you chose not to. Then off you fuck.
Okay, but you'd agree Jones is making the statements in this particular on the phone call to the informant, right? In Jones versus State.
Yes.
Okay, all right.
Yeah, so Jones was the defendant. The defendant isn't involved in this jailhouse call. He's only referenced to. He didn't make the call. He didn't receive the call. Jones shouldn't be applied here.
And it's
So,
in addition,
but Bean's making the statements. So, what theory, other than the fact of context, are they admissible? Because in Jones, the court goes on to say that as a result, Jones's statements, the court determined that they were admissible as admissions of a party opponent. So, if Bean's making the statements and he's making the statements about context, how are they admissible against Mr. Williams?
again, Your Honor, because it's the context of what they're talking about. Mr. Steele has already, a couple things.
As MD Law says, if Bean was the defendant, which he isn't, then it could be admissible as statement of party opponent or statement against interest. Mr. Bean he is not charged. He was never charged under the RICO Act. He's not a party opponent, and you already excused him. Off you fuck.
One, it puts in the other calls that I just referenced. 2, Mr. Steele, through his cross-examination of Adrian Bean, has insinuated that Mr. Bean was lying about interjecting Mr. Williams into this incident.
But it's still hearsay.
But so this also would be a prior consistent statement because
No!
Adrian Bean, because when Mr. Steele was cross-examining him on the stand, he said, you only did this just to put Mr. Williams in it. Mr. Williams is just lying, all of these things. However, he had a jail recording call that was consistent with what he told Detective Quinn during his interview.
And you chose to not play during Mr. Bean's.
Previous statement on a jail recording would be consistent.
It's still
He was
hearsay.
trying to put Mr. Williams into this case just to put him in. He had already said that before his interview with Detective Quinn also. So it comes up for a number of different reasons, Your Honor, but it's a prior consistent statement. We do believe it also provides context. And so again,
Well, the predicate under Jones is it provides context.
Right.
Then you have to have a separate admissibility theory or basis. And so you're saying it's a prior consistent statement.
yes, Your Honor. And remember that, it was all the information that Detective Quinn made Adrian Bean lie. Detective Quinn wanted Thug into this case. Detective Bean was just putting Thug into the case just to put Thug into the case. Those types of questions came out on cross-examination, and this would be evidence of a prior consistent statement of Mr. Williams' involvement in this case prior to Mr. Bean ever being interviewed by Detective Quinn. And again, lastly, Your Honor, before I sit down, Mr. Steele said that Adrian lied, but to rebut that argument of recent fabrication, again, this would be a prior consistent statement.
Well, that's what a prior consistent statement does, is it rebuts prior fabrication.
Yes.
All right, Mr. Steele.
This is infuriating because they were done. Mr. Steele made his objection, made his argument. Miss What's-Her-Face made her rebuttal to that. Mr. Steele made the final say. But the moment they saw they were about to be ruled against, oh, by the way, Your Honor, here's some vaguely things that we will do word salad on in hopes that you will make a ruling for us. This is bias. Because what the judge should have told, no, Miss What's-Your-Face, you already made your argument. We're done. If you have any, if you had more, you should have said it. You didn't. Here's my ruling. But this judge has no spine.
The prior consistent statement, it would be of Mr. Bean. I've only challenged Ms. Courtney Beans. This is not a prior consistent or inconsistent statement of Courtney Bean. She has not testified.
They're saying it's of Mr. Bean, not his wife.
It can't be a prior consistent statement because Mr. Bean is the only one who testified. I've challenged Courtney Bean's statement. I'm not challenging Mr. Bean's statement. He talks about lean in all these recordings and to Detective Quinn. I'm not challenging that. So prior consistent statement does not work respectfully. And that's also under Tomei, T-O-M-E from the United States Supreme Court, Bob, B-A-U-G-H from the Georgia Supreme Court, Adams from the Georgia Supreme Court. And the improper motive has to be challenged, and the statement has to be before the improper motive. This is the improper motive already happened, and then these jail calls. But that's irrelevant because that would be Mr. Bean's statement. I've challenged Courtney Bean. In addition to that, I think that the state is still going back to, it puts things in context. We don't need any context. He's already talking. He being Mr. Bean's already talked about lean the whole time. So I think it is for the truth of the matter asserted. It's not, and it is not non-hearsay. And I ask the court to redact that portion.
Okay. Christina?
Why are you allowing her to talk again?
On the record, so what is it? All right, Ms. Hilton, I'm back on the record, so what does he want to tell me? And I think Mr. Short has something he wants to say.
Your Honor, we just want to add that.
No, for fuck's sake! Shut the fuck up! No, Mangelo, stop giving her the last word. It's Mr. Steele's objections. He gets the last response. Stop it, Your Honor. Stop being biased. We just had a 2-hour debate on you being biased, and you immediately show bias. Oh, just one more thing. No, sit down. Shut the fuck up.
Mr. Bean's responses to what Ms. Courtney Bean said would be an adoptive admission to his co-conspirator, which would have been Mr. Williams in this particular incident, Your Honor.
No fucking no. This is Mr. Bean's wife making a claim that another person said. It's double hearsay. Even if Mr. Bean was still on the stand, it would be questionable. But Mr. Bean is not charged. He's not the party opponent. It does not apply. Jesus Christ. And co-conspirator, Bean is not charged. He cannot be a co-conspirator. He is not charged. He's not a party opponent.
How's an adoptive admission? An adoptive admission is something along the lines of, I say that you're a child molester, and you'll deny it, or something that you would ordinarily deny.
Question number one.
I'm pretty sure adopted admission went out in January 1, 2000.
Hi, Toe. No, because all of this delay. You defense, you are delaying things. There's no trial today. At the end of this, the judge says no trial on Thursday and only a half day on Friday. This is directly after he makes claims that the defense is delaying things. And then he says, we're having Thursday off. Sorry, Told. Yeah.
I believe it did, but could you check, please?
Yeah, I'm looking at Carlson's, the 8th edition, but I'll look again.
What the actual fuck? Yeah. As Gigi says, all of Mr. Bean's charges was dropped. He's not a co-conspirator.
E 24-8-801. E 2. B is a barrel.
D2B?
B. Still there.
Do you have any argument, or do you have any further argument as to whether that is an adoptive admission?
Yes.
Okay.
This is not adopted. It's not adopted by anyone. It's an admission by a party opponent. Admissions shall not be excluded to the hearsay rule. An admission is a statement offered against the party in which a statement of which the party has manifested an adoption or belief in its truth. It's a lie. The lien deal is a lie. That's the whole point. I need Miss Bean here. She's attributing something to Mr. Williams, and the state is just arguing anything to try to get it in because I can't cross-examine. So it is hearsay, and it does not fall under an exception to the hearsay rule.
But that's what the deal said. He's claiming that the lien deal is a lie. In this prior consistent statement, and this is a lie that Agent Bean made up during his interview. Therefore, we are able.
Then Mr. Bean is if it's even remotely close to being admissible, then Mr. Bean is the person to bring it through, not Detective Quinn.
To bring in the prior consistent statement of him and his wife talking about this lien deal prior to him allegedly making it up during his interview. If you look at the timeline, Your Honor, these calls have been between the 11th and the 16th. He meets with Detective Quinn on the 17th. So these that
Okay. Okay.
So I skipped through. Yeah, as no Kurosan says, then the witness should be available for cross. And she's not.
to exclude. All right, I'm going to exclude 1035 to 1056.
Yay!
I believe it is. It's hearsay. So I'm going to exclude it at this point.
Here's
Okay,
the
so
thing.
we need to redact it. All right, folks.
Here's the thing. I think the only reason the judge did this is because Mr. Steele motioned for him to recuse himself due to bias. I think he definitely would have allowed this in if Mr. Steele hadn't filed that motion. Sadly. Because I have no faith in this judge whatsoever. None whatsoever. I respect the position of a judge. I have no respect for the person currently occupying the space. None whatsoever.
It's nearly 6 o'clock. I'm gonna just call our jurors back in. I want you all to redact it. I believe that we are going to be tomorrow is going to be an administrative day. I think I take up something. And then the 22nd Friday, we'll come back at about 12:30 for a 1 o'clock start time. Mr.
Now who's delaying shit? Shit.
Sorry, just have a seat just a second, okay? All right, Mr. Steele, I'm going to just, and for others, okay? This is exactly why the court tells everybody or has told everybody ad nauseum about preparation.
You ass. You absolute fucktwat. You absolute ass. If you hadn't yelled and screamed like a spoiled 3-year-old, this would have been the hearing about this evidence. You are the reason this took so long. You and you alone, Judge Glanville.
We started back, we had a conversation about Mr. Steele's motion and the court's response to it, but we recessed at 4:32. We came back at 5:23.
Because of you, Your Honor. You entitled, spineless garbage.
And it's almost 6 o'clock at this point in time. That is exactly why the court asks all the parties to go ahead and see if you can resolve what you can resolve, or let me know so that.
You absolute fucktwat. You were given every piece of information you needed to by Mr. Steele. They didn't know this was how the prosecution was going to use those jail calls. This was presented at the time. Mr. Steele made a timely objection and wanted you to make a ruling. And you went hysterics on him. Complete hysterics. Uncalled for. This is all because of you, Judge. This hearing would have been 15 minutes, 15 minutes long, if you had been a neutral judge. But you are not. You're a spineless coward.
We don't have a jury that's been parked back there for nearly 2 hours. That's why I'm kind of really incessant about us being prepared. Now, routinely, we also have, is there anything you take up for bringing the jury? I really don't want you all to. I do that as a matter of courtesy, but it seems like there's always something I got to take up. If we need to start coming an hour early so you all can exhaust all of those issues, we can start doing that.
Your fucking honor. You are late. Now, on occasions, a juror have been late, but the majority of every minute of being late in that courtroom is because of you. And you alone.
because that's the challenge, and therein lies the challenge for the court. It's your jury, folks. You spent almost 10 months picking this jury. Now,
11.
and I told you that the jury who gets a chance to kind of proceed through what's being heard is better and more content. So that's why, Mr. Steele, when I said you weren't prepared, it's not because I don't think that you are a worthy adversary or you're not representing Mr. Williams to your capability. I'm just stating that this is my concern. It is not directed to you personally as a unprepared lawyer. This is just an example of why, and I think I've kind of had everybody to task at some point in time on this particular issue. It's not my intent to make you feel any way other than just do better. That's all I'm asking everybody, just do better. And just let me know whether or not we need to kind of park in place and then go ahead, and we could have probably taken this up at another day or whatever else. I cannot believe that after the amount of time you'll have with this case, that you haven't gone through some of the relevant things, because we've been on the same act for a period of time. And had we and even though you might have said, you still don't have any reason to doubt, you didn't say, well, we need to take this up. It's just the timing and the preparation, and it could have been done a lot better. So to that extent, that's what happened. As to your motion, sir, you're welcome to file a motion to recuse me. I cannot prevent you from doing that. Certainly, if you do so, I'll deal with it accordingly. And I'm going to deny your motion for mistrial. But that's kind of where we are at this point in time. I've told every lawyer in here, this is one of my concerns as a trial judge for many, many years. I've debriefed hundreds of juries. That's something I'm trying to give you the benefit of, is not stop and start. Let's just, streamline it as much as possible. So with that, I'm going to call our jurors in. I'm going to recess them until Friday at 12:30. And then you can take up whatever else you want to. Is there anything else? Okay. All right. Summon our jurors for us, please. Sergeant Brown. Oh, Mr. I'm sorry. Before you do that, Mr. Chart, anything?
Well, yes, Your Honor. And I understood that you were taking up after the jury was dismissed, but I do now. I just want to put this on court's radar. I understand Mr. Steele's motion. I agree. I also.
What motion?
I mean, the concerns about these recordings. I also.
Detective, can I get you to step out just for a second? Okay, please, sir.
Yes, sir.
Thank you.
And.
Hold on, wait 1 second.
Yes, Your Honor.
Okay, with the recordings, you left off of that.
Yes, Your Honor. And Mr. Steele just argued about Courtney Bean's statements. My argument is that Adrian Bean's statements on the jail recordings at this point are inadmissible. And Your Honor.
Talk about the rest of it, not just the excluded portion?
Yes, all of Adrian Bean's, and this is why. The way I see it, there's two possible arguments. Prior inconsistent statements. The state on other recordings laid the foundation for prior inconsistent statements.
Yeah, but you've examined Mr. Bean, right?
But Your Honor, if you look at, that is correct, but.
And did you examine him about these particular stuff?
No, we did not. No, we did not.
Could you have done that while he had him on cross? Could you have done that while he had him on cross?
I absolutely could have.
Okay, all right.
But Your Honor, the rule is the proponent. It's 24-6-613, and as well as.
We've already admitted the evidence, and that's you're talking about.
I'm not referring to the ones that were admitted. I'm referring to the
what
other
are you
ones.
referring to? Are you talking about Charlie? 175 Charlie, because that's what we're talking about right now.
Okay,
And
so
Mr. Steele has successfully argued for me to omit 1035 to 1056.
I'm referring.
So you're asking for the entirety of states 175.
Not the one that's in
Charlie?
evidence, but my understanding is we were talking about all three: Charlie Delta, and Charlie Echo.
The only one that there's an objection as to right now is Charlie.
Okay, I am objecting to Delta and Echo, and to Mr. Bean's statements as well. And if you look at 24-6-613, which is prior statements by witnesses, and it says, okay, excuse me, 24-8-801, D1C, a statement shall not be hearsay if the declarant testifies at the trial.
Which he did.
Or hearing, and is subject to cross-examination concerning the statement.
Which he was.
That's where I disagree, Your Honor. The state in certain jail calls and in Detective Quinn's interview, the state and Miss Love, and I understood what she was doing at the time. She asked very specific questions and confronted Mr. Bean with things that were said. That was not done, in my opinion, for these additional cell phone calls. She did not say, did you say to your wife, Courtney Bean, on this date, yada, 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 and have him either say, I don't recall or deny. So I don't believe the foundation was laid for a prior inconsistent statement. Now, as far as prior consistent statement, which is Ms. Hilton's, what was her stated argument, if you look at the prior consistent statement statute, which is 24-6-613, it talks about in examining, I said, It said, and it talks of,
Not Snivels makes an excellent point. The judge need to shut the hell up, listen, and make the state argue instead of doing their jobs for them. Yeah, and he does this all the time. He is supposed to listen to the defense, then turn over to the prosecution. What's your argument? Then go back. Okay, do you have any final? Instead, Judge Glanville is making statements on behalf of the prosecution. That's bias.
of consistency with the testimony. What in this case, the state, as it appears to me, they have a prior statement which has been admitted into evidence. And if you look at Cowart v. State 294, Georgia 333, and all the other cases they talk about to rehabilitate the testimony. There was no testimony. All we got on the stand from Mr. Bean was, I don't recall, I don't recall, I don't recall. They are trying to rehabilitate. They have a prior statement made by Mr. Bean, and they're saying prior to this prior statement, there's a motive for recent fabrication, so we want to go behind that. But I can't find any case law that suggests that you can rehabilitate a prior statement that was not testified to on a stand. So on the stand, we got nothing from Mr. Bean. So I don't believe that there's anything to rehabilitate under the prior consistent statement statute, because all we got on the stand, I think we probably all could agree, all we got on the stand was, I don't recall, I don't remember, or I don't know. And while that is sufficient to lay the foundation at times for a prior inconsistent statement, if done correctly, in accordance with the rules, I can't find any authority to say that, in Cowart, it says prior consistent statement of witness admissible only when witness was impeached by some affirmative charge that witness's testimony was tainted by recent fabrication, improper influence, or improper motive, and the prior statement predates the alleged fabrication. It talks about testimony. There's no testimony that was provided by Mr. Bean. It was just, I don't recall and I don't know. And I understand that they brought in prior statements he made, but if I read the statute correctly, the plain reading of the statute, and also I don't see any case law that would support the argument that they can rehabilitate a prior out-of-court statement with other prior out-of-court statements. And that's my argument.
Thank you, sir.
Thank you.
Ms. Love?
Thank you, Judge. 246613C says a prior consistent statement shall be admissible to rehabilitate a witness if the prior consistent statement logically rebuts an attack made on the witness's credibility. A general attack on a witness's credibility with evidence offered under section 246608 or 609 shall not permit rehabilitation under this subsection if a prior consistent statement is offered to rebut an express or implied charge against the witness of recent fabrication or improper influence or motive. The prior consistent statement shall have been made before the alleged recent fabrication or improper influence or motive arose. So as to the argument that it is not a prior consistent statement because Adrian Bean did not recall, it's not one that carries merit, because the statute specifically, and what Mr. Steele did specifically, was assert through his cross-examining questions that Mr. Bean was lying in the interview with Detective Quinn. That is the recent fabrication.
As I understand it, even if correct, that has to be done through Mr. Bean, not through Mr. Quinn. But that's my opinion. I'm not entirely sure, because as you all know, I'm not a US-based lawyer. I work out of Sweden. But I do know the foundations of law, and I am been covering this fucking case for, in 2 months' time, I've been covering this case for a whole year. I'm getting a lot of this. And thank you. It is not a recent fabrication. It was on the other recordings that he lied to the prior detective. Yeah. This is not recent. This is 11 years ago, or 10 and a half years ago.
The prior jail call, the statements made in the jail calls prior to that are being offered to rebut against. That's as to the prior consistent statement.
There's always one. Ben Real, the peacekeeper, your opinion is meaningless, then off you fuck. You nothing about US law, you're wrong, or the crisis with gang violence in black communities. I don't care. This is a court of law. The rules of the court, due process, how to admit evidence, how to testify, how to evaluate evidence. I'm trained and I am applying that training in this setting. And it all boils down to innocent unless proven otherwise in a court of law. Innocent unless proven. The state has 100% the burden of proof. If you want to do anything about, if you want to have me making a political statement regarding gang violence in urban areas, in cities in the United States, I'm not a politician. You vote for them. Ben Real, the peacekeeper. You are one of the who can vote. So why do you attack me for something you can do something about? Stop projecting, asswipe. Go do something about it yourself.
To the prior inconsistent statement, Your Honor, what I did when asking Adrian Bean the questions that I asked was, did you ever at any time, I said, did you ever at any time talk with your wife about the lien and the $50 and the $150? I asked specific questions that went to when he said, I don't recall. I would not only ask him about what he said to Detective Quinn or what he said during a specific jail call, I would broaden it and say, did you at any time during this time from September 11th to September 16th talk with your wife about X, Y, and Z? So Mr. Shart's argument that the state did not properly lay a foundation for impeachment or for prior inconsistent statements to come in is meritless, because the statute now and the case law now does not require that you, with the level of specificity as to a date and time, meet him with all of those. I asked him specifically about jail calls that he made with his wife, and specifically asked him, did you ever at any time speak with your wife about X, Y, and Z? Do you recall any conversations you had with your wife while you were in the Fulton County Jail? So the argument that Mr. Shart makes that they are not prior, that certain statements that we're arguing are prior inconsistent statements.
No, his argument is about recent. Yeah, and that there is no actual statute to this specific. Yeah.
And that we are not able to impeach Adrian Bean's trial testimony is inaccurate, because I laid the foundation for the admission of all of the statements that we're attempting to put in through the jail calls that he made.
All right.
Briefly, under 24-6-6-13 says, extrinsic evidence of prior inconsistent statement by a witness shall not be admissible. And I think we can agree that this would be extrinsic evidence. Shall not be admissible unless the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or in the interest of justice.
So you didn't avail yourself of that during cross-examination, Mr. Shaw?
Well, but
Answer my question.
I can agree with that, but I can agree with that, but the witness himself, the state is essentially saying that we can lay the foundation by saying, did you ever say this? Did you ever say that? That's and what I'm saying is, on the statute, it says is first afforded an opportunity to explain or deny the prior inconsistent statement. It's still, the statute itself is anticipating that he's going to be confronted with the statement, not just with a broad, have you ever said this in your life, with the statement. And so I am arguing that state, and I'm aware of the law and what's required, and they don't need to say the date or time, but I don't believe that just saying, have you ever said this, is sufficient.
And Mr. Bean, is not on the stand anymore, and he has been permanently excused. And I believe the prosecution did that just because of this, and this alone.
To confront him
Sit
with that
down.
statement. And that's my argument.
And Your Honor, I did not say ever in your life. I said, did you, while you were at the jail during this time frame, did you speak with your wife about lien? Did you ever talk with her while you were in jail from this time to this time about the lien, $50, $150?
All right. Okay. All right. So based upon the arguments, your arguments in the cases that you cited, and the
He is going to allow it.
in the court's consideration, I'm going to admit states 175 Alpha Bravo Charlie subject to a redaction. Charlie subject to a redaction of 1035 through 1056. I'm going to admit states 175 Delta and Echo.
And Your Honor, those are Charlie Alpha, Charlie Bravo, Charlie Delta, and Charlie Echo. So there's a C.
Well, you don't make things so
I
difficult.
know.
All right. So state those again, Ms. Love.
State's Exhibit 175.
The ones that you're offering for the purposes of this particular
Yes.
It's 175 Charlie Alpha,
Charlie Alpha.
Charlie.
Hold on. Charlie Alpha.
Charlie Bravo,
Charlie Bravo.
Charlie,
Charlie.
Charlie Delta,
Okay.
and Charlie Echo. But Mr. Steele has an objection to a portion of Charlie Echo that we just haven't addressed yet. We can address it on Friday.
All right. So you all so we've dealt with Charlie,
Yes.
that particular portion.
Yes.
All right.
So I believe the only other objection is the Charlie Echo, and we can discuss that on Friday. Or at the course of
Excuse me. All right, and how long is a portion, Charlie Echo that I need to hear?
And correct me if I'm wrong, Mr. Steele, it is 4 minutes, 4:15 through 4:55 is what Mr. Steele objected. So about 40 seconds.
Have you put the thumbs up to this stream yet? I think I deserved all
Is that
the
correct?
thumbs up you can ever give me.
Is that what you
During
want to
this
tell me,
stream.
or is there something else?
Yes, sir. Your Honor, the court admitted that exhibit ending in E. That's what I wanted to alert you, that I did have the 40 seconds that Ms. Hilton, District Attorney President Hilton said. Yes, I'm objecting to those portions, that 40 seconds.
All right, well, I'll withhold ruling then on, so I'm going to admit Charlie, 175 Charlie Alpha, Charlie Bravo, Charlie, I will exclude those portions from 1035 to 1056. I'll admit Charlie Delta, and I withhold on Charlie Echo until I rule upon the section from 415 to 440.
Somehow, this is still green. Let me do an update here. I have no idea how this is still monetized. I have no clue. All right, we have about 18 minutes left. And as you might have noticed, very few, if any, ads. At least nobody has complained about it. But the final 20 minutes, I'm putting, I will show you, by the way, how I do it. Hold on. Dun, dun, dun. This is how you turn on ads and try to stop ads. It doesn't always work sometimes because monetization is on, but I haven't chosen yet. So I will actually show you. Here, monetization. Here you see insert mid-roll ads manually. I haven't yet. That's why you haven't seen any. Here, conservative. That will mean maybe you will get an ad and maybe that will bring me a buck or two on this stream. It will be turned on for the replay crew with ads every half hour or something for the replay crew. But yeah, so now the final 20 minutes of this, you might get an ad there. And that is just to help this channel to stay afloat and give a little surplus that I will use during my road trip through America in August. Which, of course, I will make streams and videos all about it, so you can follow along when I go to Houston, from Houston to Atlanta, from Atlanta up to Delphi, and from Delphi up to Michigan, where I'm going to meet up with Dave at Making Law Simple Network. And we are going sailing, I heard, which, of course, I will make videos on. So you can all follow along on that ride.
455. Yes, I will. Yes, I overrule, but I'll go ahead and use that. I'll authorize it to continue. All right. I want you all to come tomorrow at 12:30. Yes, no, hold on. On Friday, the 22nd of March, I need you all to come at 12:15. We'll take up the 40 seconds before our jury comes at 1 o'clock.
Yes, Your Honor. Thank you.
Does that work for you, Mr. Steele, and the others? Okay, now, do you all see the time again? It's 6:20? This is again, why I kind of tell you all this. It's not just because I want to get annoyed and angry at everybody, okay? All right, but I will go ahead and remember, I'm going to excuse the jurors for tomorrow. Now, Detective Quinn, he's not available. He is available Friday?
He's available Friday, Your Honor. He's unavailable next Tuesday, Wednesday, and Thursday, but we have a Friday.
Is there any way you can ask him about his availability, or I will? Okay.
Okay, let me show you this. This is my planned route through the United States. Houston, I might go down to New Orleans, Montgomery, Atlanta, up to Nashville, Louisville, Delphi, and then Detroit. And a few stops along the way because Kaiser Pineapple has invited me into for a barbecue. And Mo in the Deep End, I will visit as well. And I will make stops, but these are the main things. And this is, when I will be in Houston between August 8 and August 12. Then driving up to Atlanta, making stops on the way. Same here, Chattanooga, Nashville, Louisville, Delphi, stuff like that. So I will make, when? I will fly to United States on August 6, land on August 7, Houston, August 8 to 12. Then I will be taking around 6 days, I think, 6 or 7 days to drive up to Detroit. And then on the 22nd, I will fly back to Sweden. Yay! So I will make notes on the community section where I am roughly around what time. So we could have meetups. Yay! Okay, back to the back to the trial.
I will ask him when he comes in. In fact, can you have our Detective Quinn come in, please?
But I'm not going. I will be outside of Detroit with Dave at Making Law Simple Network. So I will not be in Detroit.
Detective Quinn, can you join us for a second? We're just doing some scheduling, sir. Sir, we will not be in court tomorrow. We will be back in court on Friday. I'll need you to come for 12:30. Does that work for you?
That's gonna work.
Okay, Monday the 25th of March. Are you good for that day?
Monday is clear.
All right. What about the rest of the week? 26th, 27th, and 28th?
I'm making TV on those days.
Making TV on those
Yeah,
days.
we got our producers are flying in and we'll shoot like 3 hours.
Yeah, for you who don't know, Detective Quinn has a TV show with Detective Velasquez. If you don't remember Detective Velasquez, he is the one who admitted under oath on the stand that he destroys evidence. Yeah. And they have a TV show together. The rest of the world is busting their ass just to get by, and those two cops get a TV show. A true crime TV show. Here's an idea for an episode. You get charged for destroying evidence.
On each day or just one of those
For 2
days?
days, and then I have colonoscopy on the 28th.
More information I want to know,
I'm
but
just saying. I mean,
appreciate
it's gonna be a
you
little-
sharing.
I'm keeping it 100 with you, you know, I mean, so I'm gonna be a little out of that day.
You said on the 26th, 27th, and 28th, you otherwise not be unavailable. You'll be unavailable.
Yes, sir.
You'd be available for the 29th, that Friday.
Yes, sir.
Okay.
I can do that.
All right. State's Counsel, Ms. Levin, Ms. Hilton, Mr. Atkins. Do you all have any other witnesses that will otherwise be available those Tuesday, Wednesday, Thursday? If we excuse Detective Quinn for those days and have him come back on Friday? Okay. All right. Counsel, for any of the defendants, do you wish to be heard on the issue of if I were to authorize Detective Quinn to be basically we would resume his testimony on Friday the 29th. Continue. Does anybody have any objection? All right. Anybody else? Okay. All right. Detective, then we'll see you tomorrow, and then with that, and so I said Friday. Did you have anything else the following week? If we should.
All right. Now we know there will no trial today, and tomorrow they will be start. He claims they will start at 1 p.m., which no, that won't happen because he is always late. But tomorrow, what the hells? And I will do a recap and I will catch up on this trial on Monday, because tomorrow is just a half day in this court, which means, I don't know, 90 minutes tops of content, and I can get through that in no time. So tomorrow, what the hells, another hearing day, and tomorrow I will also, and I already regret it. Tomorrow at around 6 p.m. Eastern Time, we will be listening to what the hells, and every time the judge in that hearing says totality of the circumstances, I will take a shot. Hey, it's Friday. Why not? Why not? It's a clusterfuck of a hearing. Let's get entertained in some way, at least. All right. I will be sending you off to Broken Baker, who is doing a stream about the Karen Reed case. And so, yeah, thank you all for being here. Thank you all for allowing me to try to translate these proceedings for you with snark, shouts, curse words, and everything. And hug your family. Unless your family is shit, then fuck them and give your love to the people who deserve it. Okay? See you around. Bye-bye.